The Eastern Caribbean Supreme Court invites
Good morning for just some of you joining us live. This is the official opening of the law year, and the Chief Justice, Dame Janice Pirara, is getting ready to take the salute and then to inspect the guard with Acting Commissioner Don McKenzie. The inspection of the guard is something steeped in tradition. Way back in the 19th century, we adopted this tradition from the UK, and it has been a couple of years since the inception of the court in 1967 that we have been doing this as a tradition. She's now taking the salute from the commander of that platoon, and Behind her is the Chief Registrar, Mrs. John Tibbles, Michelle John Tibbles, Commissioner of Police Acton, and his deputy, and the leader of the band. Okay, so the Chief Justice is now getting ready as the platoon prepares for her inspection. As I said earlier, this is steeped in tradition. We have done this over the years, and this is the 12th year the Chief Justice will be doing the inspection. The platoon is very small this year, but notwithstanding, we have to continue the tradition. Yeah. We'll let you take a little bit of the music from the band while we look at what is going on. The Chief Justice normally engages the platoon while she's doing this little walk around. It's a nice time to see the officers all well stacked and dressed up, and it was very swift and quick. The inspection is done. She now retires to the podium again to take a final salute by the head of the platoon. Yes, and as we said, it's a very short and simple ceremony. The judges will now retire to their holding area before they are officially escorted to the bench, and the proceeding will start in the next 20 minutes at 10 o'clock. So it's the Chief Justice with the Chief Registrar, followed by the Justices of Appeal. They are in order of seniority as they retire to the holding. They're accompanied by their orderlies, the High Court judges, again in order of seniority, followed by the Attorney General from St. Kitts and Nevis, the Attorney General of Grenada, and then the Bar Association members. Great sight, good lesson in civic and history for students who are aspiring to be part of this legal profession. I see we have some students from all of the secondary schools in Grenada who will be participating in this event this morning. Let's take a little bit of the music from the band. So this was the band, the government band from Grenada. And now we watch the platoon's dismissal. Yeah, they have a few little things to do before they arrange for the official dismissal. So that will take us to the end of this little ceremonious part of the official opening of law year 2014. And they have finally retired, led by the platoon leader or the commander, and small contingent of probably about 27 or 30 plus.
The Eastern Caribbean Supreme Court invites you to the opening of the 2024 Law Year. Join Her Ladyship, the Honorable Dame Janice Pereira, Chief Justice, and other distinguished speakers from the inner and outer bar across the OECS on Friday, 12 January 2024 at 10 a.m. as they address you live from the Radisson Resort in Grenada on the theme Innovation and Justice Reform, the ECSC Looking to the Future. Brought to you live from your local GIS stations, YouTube, and on the court's website at www.eccourts.org. The ECSC opening of the Law Year 2024. It's your court. Don't miss it. The Eastern Caribbean Supreme Court invites you to the opening of the 2024 Law Year. Join Her Ladyship, the Honorable Dame Janice Pereira, Chief Justice, and other distinguished speakers from the inner and outer bar across the OECS on Friday, 12 January 2024 at 10 a.m. as they address you live from the Radisson Resort in Grenada on the theme Innovation and Justice Reform, the ECSC Looking to the Future. Brought to you live from your local GIS stations, YouTube, and on the court's website at www.eccourts.org. The ECSC opening of the Law Year 2024. It's your court. Don't miss it. The Eastern Caribbean Supreme Court invites you to the opening of the 2024 Law Year. Join Her Ladyship, the Honorable Dame Janice Pereira, Chief Justice, and other distinguished speakers from the inner and outer bar across the OECS on Friday, 12 January 2024 at 10 a.m. as they address you live from the Radisson Resort in Grenada on the theme Innovation and Justice Reform, the ECSC Looking to the Future. Brought to you live from your local GIS stations, YouTube, and on the court's website at www.eccourts.org. The ECSC opening of the Law Year 2024. It's your court. Don't miss it. The Eastern Caribbean Supreme Court invites you to the opening of the 2024 Law Year. Join Her Ladyship, the Honorable Dame Janice Pereira, Chief Justice, and other distinguished speakers from the inner and outer bar across the OECS on Friday, 12 January 2024 at 10 a.m. as they address you.
Justices of Appeal, Judges and Masters of the Eastern Caribbean Supreme Court, Her Excellency Dame Cecile La Grenade, Governor General of Grenada, and Their Excellencies, Governors, Governors General, and Heads of State of each of the Organization of Eastern Caribbean States, Member States, and Territories. The Honorable Dickon Mitchell, Prime Minister of Grenada, and Heads of Government of each of the other OECS Member States and Territories. Retired judges of the Eastern Caribbean Supreme Court, members of the Judicial and Legal Services Commission, Honorable Claudette Joseph, Attorney General and Minister of Legal Affairs, Labor and Consumer Affairs of Grenada, Honorable Garth Wilkin, Attorney General and Minister of Justice and Legal Affairs of St. Kitts and Nevis, and Honorable Attorneys General of each of the other OECS Member States and Territories. Honorable Ministers of Government of Grenada and Honorable Ministers of Government of each of the other OECS Member States and Territories. Her Honor, Madam Francine Foster, Chief Magistrate Acting, and Magistrates of Grenada, and Chief and Senior Magistrates and Magistrates of each of the other OECS Member States and Territories. Honorable Leo Cato, Speaker of the Grenada House of Assembly, and Honorable Speakers of the Houses of the Assembly and Presidents of the Senate of each of the other OECS Member States and Territories. Honorable Dr. Keith Mitchell, Leader of the Opposition in Grenada, and leaders of the opposition of each of the other OECS Member States and Territories. Members of the Grenada House of Assembly and members of the Houses of Assembly and Parliaments of each of the other OECS Member States and Territories. His Excellency, Dr. Didicus Jules, Director General of the OECS Commission. Mr. Christopher Nelson, KC, Director of Public Prosecutions of Grenada, Ms. Sigilla McDowell, Director of Public Prosecutions of St. Vincent and the Grenadines, and other directors of public prosecutions of each of the OECS Member States and Territories. Ms. Siobhan Spencer Joseph, Solicitor General of Grenada and Solicitors General of each of the OECS Member States and Territories. Mrs. Michelle John Thibbles, Chief Registrar, and Ms. Danelia Chambers, Deputy Chief Registrar of the Eastern Caribbean Supreme Court. Ms. Zaimara Forsyth, Registrar of the High Court of Justice, Grenada, and registrars, deputy and assistant registrars of the High Court of each of the OECS Member States and Territories. Mr. Gregory Gerard, Court Administrator, and Mr. Francis Letang, Deputy Court Administrator of the Court's headquarters, and Court Administrators of each of the High Court offices of the OECS Member States and Territories. Ms. Jean Dyer, President of the OECS Bar Association. Mr. Francis Paul, President of the Grenada Bar Association. Ms. Diana Thomas Hunt, President of the St. Lucia Bar Association, and Presidents of the constituent bar associations of each of the other OECS Member States and Territories. Learned members of the Inner Bar and Outer Bar of each of the OECS Member States and Territories, members of the clergy, members of the Diplomatic Corps, Mr. Don McKenzie, Acting Commissioner of Police and Police Officers of Grenada, and commissioners of police and police officers of each of the other OECS member states and territories, superintendent of prisons of Anguilla and directors, heads of correctional facilities, superintendent of prisons of the state of Grenada, and directors, heads of correctional facilities in each of the other member states and territories, staff of the court's headquarters and court offices in each of the OECS member states and territories, distinguished guests, members of the media, students who are with us from the various schools in Grenada today, citizens and residents of the Eastern Caribbean. Good morning. On 12 momentous occasions, I have appeared before you for the opening of the law year to bring you greetings and reflect on the challenges and achievements of the Eastern Caribbean Supreme Court we call the ECSC. It is with no less humility, pleasure, or honor than I had on each of those occasions that I address you now for the ceremonial opening of the law year 2024. My final address to you as your Chief Justice. I am heartened to have yet another opportunity to welcome each and every one of you to our customary special sitting and to wish you all a happy new year filled with promise and the hope that God will bestow his richest blessings, wisdom, and guidance upon us all and upon all the member states and territories. And to this end, we are grateful for the heartwarming and enlightening homily by Father Rumick this morning. We thank him for the service and reminding us of the balance between justice and mercy. We are truly blessed to be once again united to continue our tradition of hosting this highly anticipated event. Last year, as we eased out of the COVID-19 pandemic, we adopted a blended approach to the ceremony, with some speakers being physically present, while others appeared virtually. This year, a greater number of us are physically present as a greater sense of normalcy returns. On this occasion, it is especially pleasing that representatives from all member states and territories are gathered here in the beautiful Spice Isle, Grenada, a first. Also, as is now customary, this year's address is being streamed live on YouTube, the court's website, and the Government Information Services websites of the various member states and territories. These innovative tools and platforms allow us to reach as many people as possible, from as many places as possible. Since its inception, the Eastern Caribbean Supreme Court has been on a steady trajectory of improving the role it plays in justice administration. Collectively, we have persevered through many challenges, adapting where necessary, and reimagining where possible. Throughout the course of our journey, we have made significant strides and celebrated numerous momentous accomplishments in our tireless pursuit of our foremost mandate, which is to facilitate access to a system of justice that is accountable and independent. This mission is an ongoing one, and I do not regard it as a destination or final stop to which we may someday arrive. Indeed, it is perpetually moving the goalposts which keep us exploring modern and transformative means of delivering justice and court excellence in a constantly changing society. As civilization evolves, so does the concept of justice. We then become more and more aware that justice is not a homogeneous notion, and that the modernization of our different social institutions necessitates new perspectives and modifications to make the justice system more accessible, inclusive, and contemporary. This brings me to the theme for this year's ceremonial opening of the law year: Innovation and Justice Reform, the ECSC looking to the future. Innovation and reform make up the mortar that connects and binds the building blocks of the justice system. Whether it is modernizing the technological resources to remedy systemic impediments to the administration of justice, reimagining processes and revising rules of procedure for greater security and efficiency, or optimizing cross-institutional cooperation within the justice system, innovation and reform are necessary tools in realizing a more fair and just society and fulfilling the court's mission. These bridge the gap between justice itself and the contemporary effectiveness and efficiency with which it is delivered. The ECSC has always remained committed to expanding and improving its processes and rules of procedure to enhance access to justice for the people of the Eastern Caribbean. Being the judicial arm of government, the court's main purpose includes upholding the rule of law and enforcing each citizen's right to equal protection of the law. Fulfilling that mandate, however, requires that we not only espouse these principles in our determination of cases which come before the court, but that we also adequately facilitate equal access to and easier navigation of the court's systems by combating structural and systemic deficiencies. But where are we now in our plan to achieve this? And what are the benefits, challenges, and opportunities that have emerged from our efforts thus far? It is crucial that in the course of our journey to procedural and technological transformation, we pause to remind ourselves of our mission and to take stock of how far we have actually come in achieving it. And so I go now to innovation. The Eastern Caribbean Supreme Court has always been committed to exploring and adopting innovations that elevate its effectiveness within the wider justice system, sometimes by choice and sometimes driven by necessity. In pursuit of our transformation, the court has relied heavily on information and communication technologies and has incrementally increased its use of technological advancements to make more appropriate and efficient use of our resources. Since 2018, we have made tremendous strides in transforming the court's filing and case management systems through our e-litigation portal, which we call the ELP. We cannot deny the very tangible benefits that we have seen since implementing the ELP. Significantly, we have experienced a reduction in delays caused by our former reliance on a paper-based system, a marked increase in the clearance rates, the greater ease in accessing and managing case files across the length and breadth of our member states and territories, allowing the court to enjoy greater ease and flexibility of operation. I am informed that here in Grenada, case backlog for civil matters has been significantly reduced. This is a feat that ought to be emulated by the other member states and territories. But what I ask is that for a more in-depth look at the court's performance, I again invite you to visit the court's website, to browse through the court's annual report, which is published there. Browse through even earlier reports in order to gain a fuller appreciation of the impact of the ELP on the court's services. The world around us is rapidly changing, and we must continuously keep our eyes on the future of technology to keep pace with the shifts in what constitutes efficient justice administration. I dare say that one of the greatest advantages of adopting a digitized case management system was most keenly felt during the crisis of the COVID-19 pandemic. Having access to an electronic means of filing and managing cases was truly instrumental in preventing a near certain crippling of the court's services during a time when being in close physical proximity was a danger to us all. Crises also produce opportunities. What courts around the world witnessed and embraced could only be referred to as a court technology revolution. The increased integration of modern technological applications into our day-to-day processes has not only made us more efficient, but has also adequately equipped us for effective crisis management. Thus far, the court has successfully implemented the ELP for the electronic filing and management of all appeal matters, civil matters in the high courts, and most of the magistracy, mainly in respect of civil and family matters, including the 3 family courts. In the magistracy, the ELP was first implemented in the family division in the state of Antigua and Barbuda in October of 2022. In July 2023, we completed the ELP links for family and civil matters in the magistracy across all member states and territories. This has allowed the e-filing and management of the current family and related domestic case types, even in cases commenced before implementing the ELP. These cases can now be digitally managed in a manner which enhances case flow, searchability, and importantly, storage and retrievability. Feedback for enhancing the operations of the system has been taken on board as it relates to the ease of payment facilities for child maintenance payments and the like. These enhancements are in progress. We have also made great progress toward realizing the launch of the criminal module in both the high courts and the magistracy across the member states and territories. The implementation of the criminal module will take us to a full digitization of case management services in all cases and at all levels of our court. A novel feature of our electronic case management system, which is being pursued, is the adoption of a cross-sectional approach by automating information sharing between the various stakeholders in the management of criminal cases. Prospective users of the criminal module will include staff from the offices of the Directors of Public Prosecutions and Attorneys General. Later, it is hoped that this will be expanded to the police and correctional facilities. It is expected that the sharing of information across agencies and the introduction of an automated data exchange system will reduce the inaccuracies and delays often caused by paper-based methods in criminal case management, facilitate ease of cross-institutional processes, and allow for the reallocation of human resources to other important tasks for greater efficiency. I am pleased to say that the criminal module of the ELP is nearing completion for full implementation, with testing for full functionality currently underway. I am reliably informed and therefore proud to announce that the first installation of the criminal module is on schedule to go live during the first quarter of this year, with a complete rollout across all member states and territories by the third quarter of this year. I should also inform you that the court has been actively engaged in sourcing and implementing electronic jury management software to complement this system. Registrars have been given a demonstration and their feedback has been positive. Such a system will reduce many of the tasks which are currently performed manually, reducing the subjectivity of the process which may creep in, while enhancing efficiency in the overall jury management process. I must at this juncture also say how elated I am by the launch of the PACE Justice Project by our European Union and UNDP donor partners, which will be assisting at least 4 of our states, namely Antigua and Barbuda, Dominica, St. Lucia, and St. Kitts and Nevis, in implementing various measures such as digitization and electronic interoperability among state institutions, aimed at criminal backlog reduction in our region. The court is poised to attract assistance from other donor agencies in the quest for digitization in all aspects of court operations across all member states and territories. It is my fervent hope that in the not-too-distant future, the court's digitization journey will be fully realized as its ICT push continues. In this era, no court can operate effectively and efficiently without using ICT tools to deliver justice. To think or do otherwise will simply be retrogression. Technological advancements must remain one of the court's top priorities for improving justice administration in our region, which is a critical component for the economic sustainability of our small island states and territories. In keeping with our ongoing efforts to improve our technological resources, the Eastern Caribbean Supreme Court in May of 2023 also launched a completely new version of its website. The court's IT team took on board much of the feedback received from the users of the site. Users should now have a more enhanced experience from the version which was in use since 2011. Searching the judgments database, which now exceeds 10,000 entries and growing, is now considerably easier, we hope, with additional parameters to allow users to access the information which they wish to retrieve more easily. Ways for enhancing the look and feel of the website are continuously being explored. Your constructive feedback is invaluable, so keep it flowing. As the court continues its ICT push, there is the opportunity to think about and plan ahead for other technological innovations from which the court may benefit. One such technology that immediately comes to mind is artificial intelligence, more popularly referred to as AI. AI entered the global mainstream, generating its own seismic event in 2023. It appears to be as powerful as it is fascinating, with the ability to accomplish feats beyond our imagination. I am sure it is not lost on any of us the divergent views emerging from the use of AI in the legal profession. It sparks interest and anticipation in the younger and more technologically savvy generation of the legal profession, while invoking the cautious trepidation of those who are more seasoned and traditional among us. There is no doubt that AI has opened an entirely new vista with the promise of a vast range of new benefits, but which will also bring about new challenges for courts and the legal profession. For example, the courts will have to grapple with questions of what is real or authentic, or from authentic sources in areas of evidence, as well as the law itself. It has also evoked a considerable degree of fear, and discussions abound about the potential to render humans extinct. Make no mistake, AI is here to stay. What we at the Eastern Caribbean Supreme Court cannot do is to ignore either the benefits or dangers of AI, which is developing at lightning speed and being integrated in every aspect of our daily lives. What I would say to you, though, is that as in all things, balance is key. We must evaluate and take advantage of the forms of AI that will assist us in overcoming the various challenges we face in making the court's processes more streamlined and efficient. New technologies like AI allow us to automate highly repetitive and routine tasks. Some useful implementations of this innovation include automated court schedules, virtual customer service agents, automated document sorting and review, and computerized report generation from applications like our ELP to provide real-time statistics for more effective management and evaluation of our key performance indicators. At the same time, judges must become aware of how to manage and evaluate AI-generated material. This brings me to a resource issue that requires our immediate attention: the speed and quality of transcription services. This ongoing challenge has affected the court on an institutional and service-based level for years. Currently, the various registries and courtrooms across the member states and territories must contend with infrastructural deficits and other inconveniences, such as the unfortunate proximity of courtrooms to noisy, busy streets and poor acoustics in the courtroom, which negatively impact the quality of the audio recordings of hearings, or in some member states and territories, not having courtrooms at all. These deficits have plagued the courts with negative consequences on the administration of justice. The use of AI-driven automatic transcript generation could assist us greatly in resolving some of these obstacles. Advanced ICT tools using AI can produce transcripts in real time with over 90% accuracy. If our court, including the magistracy, was in a position to put in place this type of technology, it would reduce the serious delays we face in transcript production, which is currently being done manually, and at no time with enough transcriptionists to carry out the tasks. These are impediments that, if removed, would enhance access to and the efficient delivery of justice in our region. The lack of or the slow production of transcripts adversely affects the lives of our people, those who have caused harm, loss, or other detriment, and those who have suffered harm, loss, or other detriment. The adoption of innovations like AI would assist in mitigating these challenges. That said, these innovations cannot happen without much needed improvements to the court's infrastructure and technological hardware. Without purpose-built, sound-controlled courtrooms that are adequately outfitted with quality audio recording equipment, the process of transcript production using AI would remain simply a wish. A low point in my tenure as Chief Justice, spanning over a decade, has been the abysmal lack of progress by the governments in providing proper court facilities which would enable the judicial branch, a co-equal branch no less, to fulfill its mandate to the people of this sub-region. A ray of hope is emerging. It seems that the state of St. Lucia is now poised to commence shortly the construction of proper halls of justice, and the court's headquarters, including the Court of Appeal, will soon be housed in more modern facilities. However, as I have done over all the years, I call upon the governments across the Organization of Eastern Caribbean States to undertake its responsibility and build fit-for-purpose courtroom facilities that are conducive to the judiciary's work so that it may more effectively execute its role as the gatekeeper of the rule of law within our societies. The reduction of delays and ultimately the backlog of cases before the court depends heavily on the financial support the court receives from the various governments. Publicly laying blame at the court for delays without asking the hard question about what resources have been provided to enable proper and efficient functioning of the court's system is, in my view, disingenuous, with the consequence of undermining the very justice system to which we must all look for the protection and vindication of our rights and for promoting a peaceful state of existence. It is past time for turning words into deeds and truly accept that real investment in the judicial branch, in all aspects of its work, is an investment in our society and our countries overall. Justice reform. While the court's incorporation of emerging technologies and modern thinking has indeed positioned it to be more accessible and effective, those innovations cannot operate in a vacuum. It is important that we complement them with structural and procedural reform initiatives to fully realize their benefits. Last year, I announced that concurrent with our ICT push, the ECSC had finally established the Long Family Division in Antigua and Barbuda. The 17th of July, 2023 marked 1 full year of the existence of the Family Division pilot project there. Measurement of the effectiveness of our court reform initiatives has required us to carefully monitor and evaluate much of the court's activities in a manner consistent with modern administrative practices. The committee overseeing the implementation of the Family Division has been tasked with conducting a full review of the practical application of the Family Proceedings Rules 2022 from the perspective of the lawyers who have the most day-to-day experience working with these rules. The committee was also asked to examine what, if any, other legislative support would be required to allow for a more holistic functioning of the Family Division, in particular as it relates to the operations of the Magistrates' Court within that division and the gateways needed for a smooth transition between the magistracy and the High Court, in keeping with the vision of a one-stop hall for all things family. This review is ongoing with the hope that a more integrated and streamlined approach will result in the future, leading to the improved ease of access and efficiency in operation from origination to completion of the process and enforcement. As with any reform, the hope is that the continuous valuation will occur for measuring whether the objectives are being met. One core objective is to bridge the divide between the court's available processes and the remedies it provides to ensure timely and effective relief in family and other domestic matters, particularly those that involve more vulnerable groups like children. The Eastern Caribbean Supreme Court has also embarked on developing model criminal procedure rules to govern the practice and procedure of the criminal divisions across the 9 member states and territories. You may recall that St. Lucia promulgated criminal procedure rules in 2008, while St. Kitts and Nevis and the Territory of the Virgin Islands embarked on the preparation of draft rules which are not yet in force. In March 2023, I took the step of establishing a Criminal Procedure Rules Committee tasked with drafting model criminal procedure rules to be promulgated pursuant to the empowering provisions under the Supreme Court order. Culling from international best practices, the aim of this is to create a harmonized and comprehensive set of rules which will act as the foundation on which to build out other criminal court reforms for supporting robust case management, improved time standards, certainty, transparency, and equity in the criminal justice system. This, hopefully, should build public confidence in the justice system. I take this opportunity to thank the members of the Criminal Procedure Rules Committee, being co-chaired by Justices of Appeal Price Findley and Ward, and for undertaking this task. I know that they are working assiduously toward this end, and I am confident that they will complete this task in quick time. That said, the current picture of our criminal justice system is disheartening. Data shows high levels of remand populations at our prisons and correctional facilities, in some cases as high as 70%, and for lengthy periods. This reflects a criminal justice system which is clearly bogged down at virtually every stage of the criminal process, from charging and prosecuting to trial and disposition, for a variety of reasons, with the bottom line being, in the main, inadequate or lack of resources. Let me be clear. The courts are but one part of the equation. The issues creating this unhealthy state of affairs are multi-sectoral and require an all-hands-on-deck approach to resolve it, ranging from proper and timely police investigations to timely prosecutions, trials, and other measures leading to timely dispositions. I therefore call on all stakeholders, including the courts, to tackle this issue as a priority, lest irremediable damage to the criminal justice system occurs with damaging consequences for us all as a people. A bright beam in the court's reform efforts in 2023 was the long-awaited completion of the revision of the civil procedure rules. As I am sure you're all aware, the Civil Procedure Rules Revised Edition 2023 was finally launched and came into effect on the 31st of July 2023. The new amendments to the rules are expected to modernize and further streamline civil practice and procedure across the 9 member states and territories by revising and incorporating provisions that further support our current legal and technological environment. Notable revisions and additions to the new rules include advancements in alternative dispute resolution mechanisms by the introduction of Judicial Settlement Conference, or JSSCs, as we call them. Judicial settlement conferences complement the court's mediation program. They were first introduced in the Commonwealth of Dominica as a pilot and were met with considerable success. It has been hailed as a positive step by stakeholders across the member states and territories. This tool should contribute significantly to reducing the court's case backlog, and I urge legal practitioners and litigants alike to take advantage of it. Another key addition is the integration of the e-litigation filing and service procedure rules into the new civil procedure rules. With other revisions in mind, such as the removal of the requirements to seek leave to apply for judicial review and to serve proceedings outside of the jurisdiction, I have no doubt that the Civil Procedure Rules 2023 will stimulate further developments in Eastern Caribbean jurisprudence. On Monday, the 15th of January this year, 3 new practice directions will take effect. They will guide the practice relating to pre-action protocols, interim remedies, and civil restraint orders. A new practice direction dealing with detailed cost assessment will be introduced shortly. Therefore, I urge all legal practitioners to adequately apprise themselves of the new rules and practice directions so that the practical benefits of this revision project are realized. I also take this opportunity to once more applaud and thank the Civil Procedure Rules Committee, the teams from the Impact Justice Project, and the Legislative Drafting Unit in Antigua and Barbuda, and all others not specifically mentioned who toiled dutifully to conclude the publication of the new rules, thereby ensuring that the court accomplished yet another milestone in the fulfillment of its mandate of improving the administration of justice in the Eastern Caribbean. Capacity building and judicial education. In tandem with structural and procedural reform, the court's capacity building initiatives are also crucial to creating a just and proportionate justice system. These strategies, which include the court's judicial education conferences and mediation training workshops, provide the court with the opportunity to better equip judicial officers, court staff, legal professionals, and court users with the requisite knowledge to make the court's processes more effective and accessible. As part of the court's efforts to improve judicial efficiency and build capacity, the Judicial Education Institute successfully hosted the annual Judicial Conference in March 2023. The conference was attended by judicial officers from all the member states and territories. One component of the conference featured an orientation program for newly appointed judicial officers. Another component was the sensitization of judicial officers, including registrars, to the amendments in the Civil Procedure Rules 2023. There were also robust discussions on various topics, including commercial litigation, Registrars also learned skills and techniques for improving court management, ethics, case management, data quality control, and other soft skills. This was then followed up with an intense case management training program for judges in June of 2023 in St. Lucia, where issues concerning procedural justice and the Eastern Caribbean Supreme Court's performance in case management efficiency were reviewed and effective case management strategies canvassed. The final event on the JEI calendar for 2023 was the Magistrates' Conference held in October. This conference focused on several aspects of the magistracy, which were targeted to promote greater efficiency. These included leadership and case management, the importance of data in performance measurement, developing self-awareness and self-management of personal emotions, utilizing and understanding the sentencing guidelines, and framing sentencing decisions, warrants and arrest, and preparation of appeals. It is expected that the Judicial Education Institute, in keeping with its mandate of continuous capacity building as a complement to judicial reform, will continue its training programs in 2024. Permit me to place on record my debt of gratitude to the outgoing chair of JEI, Justice of Appeal Gertel Thom, who took on the mantle and steered it so ably over the years. I now turn to mediation. A staple in the court's capacity building initiatives is the JEI UWI mediation training workshops, which I am happy to report finally resumed in-person sessions here in the Spice Isle in March of 2023. We are grateful to the Judicial Reform and Institutional Strengthening Jurist Project, which facilitated this training. On behalf of the Eastern Caribbean Supreme Court, I thank the Jurist Project and the Canadian government for its continued partnership in delivering impactful programs which have left an indelible mark on the improvement of our justice system. This affords a useful point for apprising you of the Criminal Mediation Initiative, which is well underway for the implementation of criminal mediation across the member states and territories. This initiative is aimed at reducing criminal backlogs, mainly at the level of the magistracy, while at the same time incorporating alternative sentencing measures, restorative justice practices, and other approaches which can further enhance the delivery of criminal justice and also go a long way toward rehabilitating young offenders. Measures aimed at rebuilding lives and livelihoods where possible generate a more lasting and positive impact than punitive measures ever could in terms of giving hope and repairing relationships, which can ultimately redound to the enjoyment of safer and more peaceful societies. The Criminal Mediation Committee, under the chairmanship of Justice of Appeal Ellis, is hard at work on this initiative, and draft rules and practice directions are nearing completion for consultation and rollout. All stakeholders, including the governments, should lend their full support to this initiative, which should aid in tackling not only criminal backlog reduction, but also help to reduce recidivism and provide meaningful pathways for young offenders to become productive members of society. Of note is that the National Mediation Committee of Antigua and Barbuda hosted its second annual Mediation Symposium and Mediation Awards on Thursday, the 27th of April 2023 at the High Court of Justice in St. John's, Antigua, under the theme Restorative Justice, Introducing Mediation in Criminal Proceedings. The symposium was attended by more than 200 persons virtually and in person, and explored the application of restorative justice mechanisms to the criminal justice system, particularly criminal mediation. Apart from the inclusion of mediation awards at that symposium, the Mediation Committee also showcased a very powerful educational video exhorting young people to embrace mediation rather than escalate disputes into acts of violence with potentially disastrous consequences for everyone. It is a video that I hope gets airtime on every radio and television station without a fee, as part of our civic duty to encourage peaceful dispute resolution. Despite setbacks, I am also pleased to report that a National Mediation Committee for St. Vincent and the Grenadines has made progress and is now housed in appropriate facilities conducive to facilitating amicable negotiations between parties. This, in no small measure, was made possible through the kind support and sponsorship of the Jurist Project. Again, I thank the Canadian government through the Jurist Project for their transformative impact on mediation in St. Vincent and the Grenadines. Continuing over the years, the court has prioritized mediation promotion throughout the member states and territories by engaging and facilitating various forms of mediation campaigns. These steps help to spread the word in the schools and in the wider community within our subregion and farther afield. Also, these steps, though small, will have a huge lasting impact over time. This work, in my view, despite resource constraints, must continue. Sustainable social transformation for a fairer and more just society requires social justice strategies that promote restorative behavior. However, the court cannot do it alone. The court needs greater support from our social work agencies to provide therapeutic interventions, such as programs that target anger management, conflict resolution, peer mediation, parenting support, and mentorship. This support would go a long way toward complementing the work of the court for more impactful justice administration. It is now time to welcome our new judicial appointees and to bid farewell to those who are no longer with us. It is John C. Maxwell who said, "Change is inevitable, growth is optional." Indisputably, over the years, the court has had to adapt to changes and has, with these changes, sought to embrace continued growth. Permit me, therefore, to welcome the most recent appointees to the bench of the Court of Appeal. His Lordship, the Honorable Eddie Ventus, who was appointed as a Justice of Appeal, and Her Ladyship, the Honorable Vivian Georges Taylor Alexander, who was appointed to act as a Justice of Appeal effective the 8th of January 2024. I also welcome the most recent appointees to the bench of the High Court. Her Ladyship, the Honorable Sonia Young, His Lordship, the Honorable Ricky Burnett, His Lordship, the Honorable Renee Williams, and His Lordship, the Honorable Alvin Pariak Singh, as well as their lordships, the Honorable Tunde Bakre, the Honorable Dale Fitzpatrick, the Honorable Paul Webster, the Honorable Richard Floyd, and Her Ladyship, the Honorable Racken Brown, who were appointed to act as judges of the High Court for various terms during this year. I also extend a warm welcome to Master Sybil Snack Dantes, who was appointed as Master of the High Court in February 2023. I wish them all a successful tenure on the bench of the Eastern Caribbean Supreme Court. I would also like to extend my gratitude to all those who assisted the court last year by answering the call for brief acting judicial appointments. In the last year, we bade farewell to His Lordship, the Honorable Paul Webster, as a Justice of Appeal, having retired in August of last year. Between 2001 and 2015, Justice of Appeal Webster undertook several temporary appointments as a judge of the High Court and the Court of Appeal, serving on a longer-term basis as a Justice of Appeal. His invaluable contributions to the court will forever be etched in the annals of our court's history. I express my immense gratitude for his years of dedicated service to the court, which he extends to us still by acting as a commercial judge in the Virgin Islands. As recent as last month, on the 21st of December, 2023, we bade farewell to Justice of Appeal Thom. She was a stalwart on the Court of Appeal, and indeed in so many areas of the court's work that time does not permit me to address here. Suffice it to say that her contributions as a member of the Judicial and Legal Services Commission, as chair of the JEI, member of the inaugural Sentencing Guidelines Committee, the Criminal Mediation Committee, and the Family Proceedings Rules Committee speak volumes in respect of the critical support she gave to me as Chief Justice and the depth and breadth of her dedication and commitment to the court. Words, in my view, are insufficient to express the magnitude of our appreciation. She can only be described as a true servant of the people. In March 2023, we also wished a happy retirement to Her Ladyship, the Honorable Victoria Charles Clark, who served as a High Court judge since September 2016. I take this opportunity to wish her every success in her future pursuits. Permit me now to recognize and reflect on the unfortunate passing of retired Justice of Appeal, the Honorable Olame Edwards, in November 2023. The Honorable Justices Stanley Moore in March 2023. The Honorable Claire Henry in June 2023. The Honorable Monica Joseph in July 2023. And the Honorable Dunbar Snack in September of 2023. The court suffered many losses in 2023. We are grateful to them for their stalwart service, and together with their families, we mourn their loss and extend our deepest condolences. Loss reminds us to be thankful, and so at this juncture, I now place on record my gratitude to all those who have helped propel the court forward and who continue to display their unwavering commitment to its future success. To the dedicated judicial officers of this court, magistrates included, I thank you for your diligence and faithful service. I urge you to continue to serve at your best. I also extend my gratitude to the registrars and their support staff at both the court's headquarters and the constituent court offices of the member states and territories. I applaud your teamwork and earnest efforts which keep the Eastern Caribbean Supreme Court in steadfast pursuit of its mission. To the OECS Bar Association and the constituent bar associations of the Eastern Caribbean, in extending my thanks to you, I would also remind you that your keen collaboration with the judiciary is important for the advancement of the legal profession and the administration of justice. We thank you for the important work that you do, and I would also urge that you continue all the good work that you do in supporting the Eastern Caribbean Supreme Court. I would like also to recognize our external partners, stakeholders, and donor agencies who have worked with us and given us much needed assistance to expand our capacity. On behalf of the judiciary, I express our heartfelt gratitude to the Government of Canada for the Jurist and Impact Justice projects, the United States Embassy, the British High Commission, UNICEF, UN Women, UNDP, USAID, the University of the West Indies, and indeed the governments of the 9 member states and territories for their support. The court's lack of financial autonomy means that your contributions are vital to its continued development and success in fulfilling its mandate. Therefore, we thank you for your partnership and look forward to its continuation. I wish to extend thanks to the OECS Commission and to all those who are not specifically mentioned, but who nonetheless have played an instrumental part in the court's success in 2023. Finally, my sincere thanks and appreciation to all the judicial officers, registrars, and speakers, some of whom traveled here to attend this special year's sitting. I am informed by my brother, Justice of Appeal Michel, that we have an entire complement of about 22 judges here at this opening ceremony of the court's Your Lawyer, and I think it is something which is truly special. It, in my view, demonstrates their support and commitment to the Eastern Caribbean Supreme Court. As I close my final lawyer address, may I say that it has been my greatest privilege to serve you as your Chief Justice. Reflecting on the last 11.5 years brings forth in me mixed emotions. It feels like a lifetime. It feels like a day. We grappled with many challenges, but we faced them together, head on. Many sacrifices have been made, but the rewards of serving in this office have been far greater. As I exit the stage, it is my hope that the court is a little bit better than when I entered. My fervent hope for the future is that the Almighty God, who has seen this court through all its challenges and who has blessed all its successes so far, will show it journeying mercies on the road ahead. The Eastern Caribbean Supreme Court's future will no doubt continue to be laden with obstacles, but more importantly, it will be ripe with opportunities. We need only to persevere with courage and resilience and pray that the Almighty will see us through. And so I thank you all for the support you have given me over the years. I wish especially to thank the helpful and dedicated staff at the court's headquarters and indeed at the various court offices across the 9 member states and territories, who made anything that I was able to achieve during my tenure possible while making it seem easy. It isn't easy work. They simply make it that way and therefore make my job that much easier. I will carry and cherish the memories of our time and the work we have done together always. It has truly, truly been an honor serving you. I thank you.
Her Ladyship, Honorable Janice M. Pereira, DBE, LLD, Chief Justice, Their Excellencies, Heads of State of the OECS, Honorable Heads of Government of the OECS, Honorable Justices of Appeal, Judges and Masters of the Eastern Caribbean Supreme Court. Otherwise, permit me to adopt the protocol list as established by Her Ladyship, the Honorable Dame Janice Pereira, Chief Justice. Good morning. Welcome to this special sitting to mark the opening of the law year 2024. I am Justice Paula Guilford, Senior Resident High Court Judge in Grenada, and your Master of Ceremonies for this special sitting. As the Honorable Chief Justice intimated, this year's opening is the first physical sitting since 2020, where all speakers are physically present here in the host member state. This year's host being our Spice Isle, Grenada. We, however, continue to embrace technology to bring us together despite the geographical divide of our 9 member states and territories. And so this special sitting is also being streamed live from here at the Crown Ballroom, Radisson Grenada Beach Resort, which has been declared a court for the purpose of the special sitting to the other member states and territories of the court via the Grenada Information Services media platforms and social media pages. It is also being streamed via the court's website and Facebook, the websites and social media pages of the Government Information Services in each member state and territory, and the UE TV. After listening to the feature address delivered by the Honorable Chief Justice, I'm confident that we have all been motivated to anticipate further enhancements in our justice system. As the court proactively reforms and innovates our services, we aim to better serve our court users and stakeholders. At this juncture of the proceedings, we will listen to the representatives from the legal profession of the OECS member states and territories. Please note that a more detailed speaker bio is available in the program. Our first speaker from the bar is none other than Senator the Honorable Claudette Joseph, Attorney General and Minister of Legal Affairs, Labor and Consumers Affairs of Grenada. The Honorable Claudette Joseph was called to the bar in Grenada in 1996 She received her legal training at the U Wooding Law School in Trinidad and Tobago and the University of the West Indies, Cavale campus. She has had a distinguished professional and legal career. In 2022, Honorable Claudette Joseph was appointed a senator in the Parliament of Grenada and holds the post of Attorney General and Minister of Legal Affairs. To address us on behalf of the Attorneys General of the OECS and as the representative of Grenada, Senator the Honorable Claudette Joseph, Attorney General.
May it please your ladyship, my lords, in the interest of time, permit me to adopt the protocol list set out before, except to recognize my lady, the Honorable Chief Justice of the Eastern Caribbean Supreme Court, Dame Pereira, other justices of appeal, judges of the High Court, masters, my colleague attorneys general across the Eastern Caribbean, but I must pause to make special mention of Attorney General and Minister for Legal Affairs and Justice for St. Kitts and Nevis, the Honorable Garth Wilkins, because he journeyed to be with us in person today. Registrar, Chief Registrar of the Court, and registrars of the constituent registries, members of the media, ladies and gentlemen here present, and those viewing online. My lady, my lords, it is my distinguished honor and the pleasure to address the court on behalf of my colleague attorneys general of the jurisdictions that are members of this honorable court. First, on behalf of the government and people of Grenada, I extend best wishes to you and your families for the new year, and I pray that it will be filled with good health, happiness, and success in all your endeavors. I also welcome all of you who have journeyed from near and far to the Spice Island of the Caribbean. The official opening of the law year is always a special occasion, and as such, it is always a privilege to be invited to address the court. But 2024 is an exceptional year. For as the court convenes to mark the opening of the new law year, we also celebrate, emulate, and profoundly thank our distinguished Chief Justice, an outstanding Caribbean daughter, for her stellar service to our court and sub-region. On this, her last sitting of an opening over which she will preside. As the court sits on this extraordinary occasion, the theme chosen, Innovation and Justice Reform, the ECSC, looking to the future, is indeed apt and in a sense speaks directly to the tenure of Chief Justice Pereira as head and leader of the judiciary in the Eastern Caribbean. The Eastern Caribbean Supreme Court stands as a beacon in the entire region and has, while facing many challenges, continued to enjoy many successes. We have been blessed with successive progressive leadership that has allowed us to embrace our ever-evolving social and economic circumstances, and in that vein, to move forward in innovative ways that continuously enhance access to justice and equality before the law for our people. My lords, I will submit that the strides we have made in the last 10 to 12 years have set us on a solid foundation from which we can look to the future with confidence, ready to take on challenges as they arise. These advances in the recent history of the court have seen us embracing technology, for instance, at a faster pace and more efficient than our bigger sisters in the wider region. The introduction of the e-litigation portal was simply revolutionary. Its value to the administration of justice became stark during the pandemic when it allowed for seamless court filings. Embracing technology in this manner makes for greater efficiency and transparency in the administration of justice. We are all pleased that the e-litigation portal has now been extended to the magistracy. Yeah, that's how technology does sometimes. Has now been extended to the magistracy, and this has been working quite well, at least speaking for Grenada. Embracing a digital paperless court brings our court in alignment with other modern courts around the world and positions us to take advantage of new technologies as they emerge. And I heard Chief Justice speak quite a lot about artificial intelligence. Moving the operations of the court to a digital platform also synchronizes well with the thrust in the other arms of government to go paperless. For instance, in Grenada, we operate a paperless parliament and a paperless cabinet. So it is in order that the other arm of the state must go paperless as well. My Lady Chief Justice, our sub-region has you to thank for progressive thinking and aggressive implementation in this regard. I say we are not just looking to the future, we are doing so with anticipation and confidence, knowing that we are already poised to conquer whatever challenges we are to face. My lady, I am sure you didn't plan it this way, but the e-litigation portal, and that's my fervent view, the e-litigation portal for all courts will be a huge part of your legacy. On behalf of the attorneys generals in all jurisdictions, I say thank you for your visionary leadership in this regard. My lords, as we endeavor to improve access to justice for all our people and to build their confidence in the justice system, we must adapt and respond to societal and economic changes. Our court is a success story, and it is a success story that it is today in part because of the boldness of its leaders, particularly former Chief Justice Sir Dennis Byron and you, my Lady Chief Justice. One of the most progressive steps the court has taken in its lifetime is the introduction of the civil procedure rules. And I say that because from my recollection, and the elders among me can correct me if I'm wrong, the 1970 rules were never revised in the period that they were in force. But the reform didn't end there with the implementation of the rules in 2000. From inception, and certainly between 2012 and 2023, we saw constant and substantial enhancement of the CPR, particularly in 2011 and 2015. However, the detail and thoughtfulness that went into the overhaul of the CPR in 2023 revision was unparalleled. Changes such as the insertion of Part 38A, judicial settlement conferences, this signals the court. This signals the court's change in focus from adversarial modes of dispute resolution to alternative dispute resolution methods, as it seeks to make justice more accessible, less costly, and speedier for all our people. Judicial settlement conferences will no doubt support and buttress the already entrenched mediation process. The seriousness with which ADR is treated is underscored by the imposition of stringent cost orders for parties who do not genuinely engage the judicial settlement conference procedure. Another thoughtful amendment that we've seen to the CPR under the stewardship of Chief Justice is that Part 7 in dealing with service, is that of Part 7 in dealing with service outside of the jurisdiction. The revised CPR 2023 is really a demonstration of progressive justice reform in action. My lords, permit me to make mention of some other matters that enhance the delivery of justice and which will focus on the progressive and visionary leadership that Chief Justice Pereira offered us over the years. The criminal justice system, we had the criminal procedure rules for St. Lucia, and the sentencing guidelines, and of course, the bail rules for all jurisdictions. We had the election petition rules implemented, and that was something that was sorely lacking in our jurisdictions for many years and created uncertainty in this very important area of the law. The non-contentious probate rules tailored to our unique circumstances as a region and liberated us from the 1987 UK non-contentious rule. I particularly am pleased for the introduction of those rules. Then we have a suite of practice directions giving guidance on areas ranging from prison video link in St. Lucia and St. Vincent to pre-action protocols and civil restraint orders in all of the territories. My lords, the common thread that runs through all of these directions and amendments and enhancements to the rules and laws is that they make access to justice a reality for all. In other words, in leading the court, Chief Justice puts the people we serve first. And so, my lords, as we thank our dear Chief Justice, it will be remiss of me as a fellow woman, and might I say a fellow strong woman, not to pause to recognize that we are emulating a sister leader, our first female BVI lander to be elevated to the bench. I was checking to see whether it was the first BVI lander altogether. I think so. I see a nod. First BVI lander to become Chief Justice. First female Chief Justice of our distinguished court. Being a graduate of the University of the West Indies. First homegrown Chief Justice. And I will add, the first true visionary and progressive head of the court. Somebody corrected me, Justice Saunders. Hold on. I wanted to add some extra first. My lords, to all of these accolades are to be added the many erudite judgments of the Honorable Chief Justice, many of them, if you pay attention, on the subject of interpretation and application of the civil procedure rules. These judgments are in themselves, in many respects, innovative and groundbreaking, and I'm sure speakers who follow me would cite some of them. My Lord, as Chief Justice mentioned just now in her address, the proper administration of justice and proper access to it also requires the proper provision of physical facilities, which is the responsibility of the executive. I am happy to report on our own progress here in Grenada with the Hall of Justice. During the year, Cabinet appointed a Hall of Justice Steering Committee, chaired by yours truly, the Attorney General, and the committee, after a study of the overall needs of Grenada, will expand the scope of the project in two respects. First, to include the building of a new mini Hall of Justice on the island of Carriacou. This will be a fit-for-purpose design to include a mediation center, a vulnerable witness room, because we are going to embark on the sexual offenses court, so a vulnerable witness room, offices for the Ministry of Legal Affairs, modern spaces for the court and the court staff, all on Carriacou. Preliminary drawings have been completed, and for this, suitable land has been identified. The second respect in which we are going to amend the project scope is to include spaces, office spaces for the Division of Legal Affairs, the Office of the Attorney General, and Director of Public Prosecutions. These adjustments to the plans for the Hall of Justice projects have been made because government recognizes that it is time for the legal function of government and all its affiliates to have proper, fit-for-purpose homes. The steering committee has made significant strides in securing the services of a project consultant. We are in the final stages of engaging that person, and soon a project manager to lead the finishing up of the design for the main structure, and then the construction, from construction to commissioning of a state-of-the-art, climate-smart Grenada Halls of Justice. Bringing all the services provided by the judicial sector on one compound, we believe will help with the ease of access to justice for all stakeholders. So, my lady, my lords, as our Chief Justice prepares to retire from the bench, I will submit that through her stellar efforts, we are left in a position poised for a future that will see our court going bravely into the next 50 years as a model regional institution. And as Grenada celebrates 50 years of independence this year, the first country in the OECS to do so, we will no doubt cite and celebrate our membership in and contributions to this court as one of our great achievements as a nation. My lords, if I may be indulged to end with these final words directed specifically to the Honorable Chief Justice and taken from the book of Numbers, chapter 6, verses 24 to 26. The Lord bless you and keep you. The Lord makes his face to shine upon you and be gracious to you. The Lord turns his face towards you and grant you peace. And if I wasn't in a court, I would sing that. May it please the court.
Thank you. Honorable Claudette Joseph, Attorney General. Our next speaker is a senator in the National Assembly of St. Kitts and Nevis and currently serves as Attorney General and Minister of Justice and Legal Affairs. He's a clinician with degrees in civil engineering and law and is called to the bars of St. Kitts and Nevis, Anguilla, Antigua and Barbuda, and Montserrat. Prior to taking public office, he practiced at the civil and criminal bars and served as president of the St. Kitts and Nevis Bar Association. To address us on behalf of the Ministers of Legal Affairs of the OECS and as a representative for St. Kitts and Nevis, Senator, the Honorable Garth Wilkin.
May it please you, my lady, Chief Justice, I beg your leave to adopt the ably established protocol that has been entered onto the record. My lady, I was examining the benches and I noted that there are 23 judges on the benches. I have appeared before 11 of those 23, and I can say that the court is in capable hands, not because those 11 ruled in my favor, but because I have received judgments from each of those 11 against me, and when I read the judgments, I still believe them. My lady, in the context of the Eastern Caribbean Supreme Court, innovating means envisioning and implementing a new way of going about the court's business. Reform is improvement on existing processes. Looking to the future means modernization. Modernization means adapting to the modern needs and habits of the society. And adaptation is sustainability. That is, maintaining and supporting the institution continuously over time. Therefore, to ensure that our treasured Eastern Caribbean Supreme Court sustains for the benefit of this and future generations, its leaders must continuously innovate, reform, and look to the future. On that thesis, my submission today is that no person has done more to shape the future of our beloved sub-regional Supreme Court than your ladyship. It is because of the bold actions taken during your ladyship's tenure as Chief Justice that we are now experiencing this modern gem of an institution and a resultant ministerial culture change. I am of the firm belief that this court, the future, is now. We are making oral submissions from Bastia while the bench sits comfortably in Castries because your ladyship led the swift implementation of our court's virtual hearing protocols during the COVID-19 pandemic and saw the benefits of maintaining virtual hearings post-pandemic. We are filing injunctions at midnight while registry clerks are sleeping because of your ladyship's leadership and bravery in implementing the e-litigation portal despite the fear and consternation in the profession. Chambers in Roseau are being officially served by email with court documents originated in Roadtown, approved by King's Council overnighted in Kingstown because of your ladyship's leadership in enacting our new innovative civil procedure rules. Justice is being served more expeditiously and transparently in criminal courts from Braids to St. George's because of the clear and concise modern sentencing guidelines and bail rules. We are a strong, modern, internationally well-respected jurisdiction and court because of the brave innovations adopted during your ladyship's tenure as Chief Justice. To you, my lady, the legal profession and the people of our proud OECS member states are forever indebted. A legend lets her work speak for itself. Your work has spoken loudly. It is on these innovative foundations we now stand, and with continued vigor, the future looks bright for our court. The court's administration, having set the trend of embracing innovation in our sub-region, has influenced the culture of innovation and reform projects being undertaken throughout the OECS. In Antigua and Barbuda, the ministry continues to develop the first model family court in the OECS for full integration of the magistracy into the family division of the High Court. The court accommodates weekly sittings of the Child Justice Board, and a brochure entitled Your Child and the Law has been published. This brochure simplifies the provisions of the Child Justice Act to bring awareness to the procedures that would apply to children who come into conflict with the law. In Anguilla, a new administrative justice special provisions bill seeks to introduce judge-only trials in criminal proceedings, anonymity orders, and special measures for children and vulnerable witnesses in relation to the reception of their evidence. In St. Vincent and the Grenadines, the ministry has made a commitment to focus on advancing digital technology to make better use of advanced technologies to improve efficiency in the way the ministry conducts business with the public. In the British Virgin Islands, the design phase of the Virgin Islands Halls of Justice is expected to be completed by the end of the first quarter 2024, and US $2.2 million has been budgeted towards the construction phase in 2024. Other halls of justice in the member states are being actively planned to permanently and comfortably house the court and its officers. In Grenada, the ministry took an important step in the development of a legal and regulatory framework for the protection of patents and convinced the World Intellectual Property Organization to provide support for a project to enhance the value and marketing of their origin-linked products, which will help strengthen Grenada's brand as the island of spice and its tourism marketing brand, Grenada, the Spice of the Caribbean. And in St. Kitts and Nevis, with your leave, my lady, allow me to highlight 3 innovations in our ministry. First, we have received budgetary support to establish, in the next few weeks, an Access to Justice agency. As a commitment towards our UN SDG 10 and UN SDG 16 goals, this Access to Justice agency will have 4 divisions. Legal aid, able counsel in civil matters available to represent indigent persons at little to no cost. Public Defender's Office, able counsel in criminal matters available to represent accused at little to no cost, and facilitation of the participation of young counsel in the criminal justice world. The Mediation Department, pre-litigation facilitation of professional mediation services at little to no cost. And the Restorative Justice Department, ensuring that victims and convicts returning to society can dialogue and move forward with their lives to reduce the number of repeat offenders. Secondly, my lady, in November 2023, our federation was the epicenter of intellectual property in the Caribbean, as we hosted the World Intellectual Property Organization's meetings of heads of IP offices and IP ministers of the Caribbean under the theme, IP Innovation to Prosperity. During that meeting, St. Kitts and Nevis became the first country in the world to launch WIPO's IP and Sports Project, aimed at unlocking the economic value of our local sports industry. We look forward to the fruits of that innovative initiative. And lastly, my lady, it is the goal of our ministry this year to fulfill your ladyship's express dream of integrating the magistracy in the ecosystem of the Eastern Caribbean Supreme Court. We have started with the implementation of the e-litigation portal for civil matters last year and intend to support the full innovative reform needed to continue the strengthening of that court, which touches and concerns the most people in our small jurisdictions. My lady, led by your example, I can safely report that the ministers with responsibility for justice and legal affairs in the OECS are innovating, reforming, and looking to the future for the benefit of the people of our region. May it please you, and may the recognition of your legacy reverberate loudly throughout the OECS and beyond.
Representing Antigua and Barbuda and the Magistracy of the OECS, Ms. Veronica E. Thomas, was called to the bar of Antigua and Barbuda Circuit of the Eastern Caribbean Supreme Court in October of 1998. After successfully completing a Bachelor of Laws degree with honors at the Cave Hill campus of the University of the West Indies in Barbados, and professional legal training at the U Wooding Law School in Trinidad. Thereafter, Ms. Thomas was appointed Crown Counsel in the Attorney General's Chambers and later Assistant Registrar of the High Court of Justice from 1998 to 2004, and currently serves as the Family Magistrate. I present Her Honor, Ms. Veronica Thomas.
My Lady Chief Justice, with your leave, may I adopt the protocols that have so ably been established by speakers before me and say good morning to one and all. It is an honor for me to be here on the occasion of the special sitting to mark the opening of the new law year 2024, and on the occasion of Her Ladyship, the Honorable Chief Justice's final special sitting, speaking as the representative from Antigua and Barbuda on behalf of the magistrates of the OECS. For the people of the OECS region, our greatest resource lies in the shared history, culture, and rich traditions of our people. We share and are affected by the same challenges and adversities. The same can be said for the magistracy of the region. Sustainable solutions can only come from pooling our resources and adopting a common and unified approach. We have to think our way out of the problem by first beginning to imagine the solution we would like to see. The theme for this new law year, Innovation and Justice Reform, the ECSC looking to the future, calls on us to do just that. The process of reform is a journey rather than a destination. We must therefore constantly review and assess, take stock of accomplishments, ensure that we're still on the right track, or if indeed some change, of course, is required. I would therefore take this opportunity to highlight some of the notable achievements in the magistracy over the last year. The magistracy continues to be positively impacted by the reform initiatives of the Eastern Caribbean Supreme Court. Following the successful launch of the Family Division and promulgation of the new Family Court rules, the Family module of the e-litigation portal went live in Antigua and Barbuda in October 2022. In 2023, we saw the rollout of the e-litigation portal in magistrates and district courts throughout all 9 member states and territories. The e-litigation portal has truly revolutionized the way the court conducts business. There is now one virtual space from which all the court offices and sub-registries of the OECS region, including our magistrates' courts, can be managed and administered. In the post-pandemic era, more technologically enhanced courtrooms in the magistrates' courts of the region allow for a blended approach to the hearing and disposition of matters. The benefits in being able to adopt this flexible approach is readily apparent when dealing with proceedings involving vulnerable witnesses. It allows the court alternative options to be better able to manage cases. A major highlight of the year was the Magistrates' Conference, which took place in October 2023. It was the first in-person conference for the magistrates since the COVID-19 pandemic. It was a most excellent conference, exceeding all expectations. For the first time, the events and logistics of the conference were managed through an app, completely eliminating the need for the printing of any conference material. The sessions in case flow management were truly a masterclass, facilitated as they were by the Venerable, the Right Honorable Sir Dennis Byron. For the first time, areas such as emotional intelligence and wellness were included on the conference agenda. Domestic violence proceedings and juvenile justice reform were also featured. More intense training, including practical exercises on the sentencing guidelines, helped to reinforce and add further clarity in respect of what is widely regarded as yet another transformative initiative of the court. On behalf of the magistrates of the OECS region, I wish to extend our heartfelt gratitude to the JEI and its indomitable chair, retired Justice of Appeal Gertel Tom, and the entire team at the Eastern Caribbean Supreme Court for the successful execution of the Magistrates Conference 2023. Looking forward, these are exciting times for the magistracy. We await with eager anticipation the rollout of the criminal module of the e-litigation portal in all member states and territories. We also look forward to the completion of the work of the Criminal Mediation Committee, leading to the establishment of a new criminal mediation practice direction, which will introduce criminal mediation in applicable cases to the courts, including magistrates' courts, juvenile courts, and child justice boards and committees throughout the region. It is anticipated that criminal mediation will be transformative in addressing the backlog of cases in criminal matters that has crept in over the years as a result of the devastating impact of several natural disasters and the COVID-19 pandemic on the operations of our courts, particularly in relation to criminal matters where technological innovations were not quite as impactful. In the area of juvenile justice reform, criminal mediation will be an additional diversionary measure available to the juvenile courts, child justice boards, and committees when dealing with matters involving children who come in conflict with the law. Innovation and reform call for creative reimagining. As the magistrate of the Family Division in Antigua and Barbuda, I feel privileged to bear witness in real time to the intersection of three projects which are pivotal to the court's reform process. That is, the integration of the magistracy, the establishment of the Family Division, and the e-litigation portal. It is the perfect example of what can be achieved when innovation meets reform. No doubt, these initiatives will be part of the enduring legacy of the Honorable Chief Justice, who each year without fail, like a voice crying out in the wilderness, continued to call for the integration of the magistracy and the establishment of the Family Division. There can be no turning back now. The Family Division is only the beginning. There is so much more that can be said, but I am constrained to wrap up now in the interest of time. I will conclude with this. It is often said that necessity is the mother of invention. However, there is an alternative school of thought that may be equally true, and that is, dissatisfaction is the mother of invention. Let it be that within the context of the integration of the magistracy into the judiciary, our efforts to reform are because we must be dissatisfied with any situation which threatens the independence of the judiciary, the separation of powers, and the rule of law. Milady, I thank you most sincerely for this opportunity. May it please the court.
Affectionately known as the Gem of the Isle, Ms. Sajila D. McDowell is the Director of Public Prosecutions of the National Prosecution Service, St. Vincent and the Grenadines. She holds a Bachelor of Laws degree with honors from the University of the West Indies, a legal education certificate from the Hewarding Law School, Trinidad and Tobago, and a master's in legislative drafting with distinction from UWI. She was called to the bar of St. Vincent and the Grenadines in 2009 and remains committed to public service through criminal prosecutions. To address us on behalf of the Directors of Public Prosecutions of the OECS and as a representative for St. Vincent and the Grenadines, Ms. Sigilla D. McDowell.
May it please you, Madam Chair and the Honorable Chief Justice, I seek leave of the court to adopt the protocol that has been so ably established. And might I add that we have started the year off right. When we look around, this is the standard of what our court facilities should look like. So good day to everyone. I bring greetings from my homeland, St. Vincent and the Grenadines, the land of the blessed, with the ashes of 2021 well dusted off. And salutations on behalf of all heads and staff of prosecuting authorities in member states and territories. Happy New Year, Happy New Law Year to all, and I pray God's corporate favor on us. I am honored to be in the midst of our Chief Justice, Her Ladyship, the Honorable Dame Janice Pereira, this esteemed quorum, and distinguished celebrants in person and online. Let us mull over the theme, Innovation and Justice Reform, the Eastern Caribbean Supreme Court looking to the future. Looking to the future does not require precognition or a prophetic gift. It is a studied awareness of where we are, reflection on where we were, and a constructive mindset towards the future with faith leading the charge. Reform compels the quality of stick-to-itiveness, so there is a natural graduation from thought to dream to blueprint to cementing a foundation to construction, demolition when necessary, and reconstruction. Can you tell I wanted to be a contractor? But as the Director of Public Prosecutions, my colleagues in counterpart offices of the member states and territories, we understand the value of cooperation and support. We run autonomous offices that rely on the interoperability of other key criminal justice actors. We eternally contract our services to the court, and over time we have been beneficiaries of the many developments, some of which we would have heard expressed earlier, led by the Eastern Caribbean Supreme Court that has transformed the pace and quality of the delivery of justice. Some examples: the pilot courts, e-litigation portal, newly introduced bail rules, sentencing guidelines, and these only scratch the surface. In Luke 6 of the Holy Bible can be found a parable of the wise and foolish builder. The wise built on rocks that withstood the torrents or the storms, and the unwise built on no foundation. So, of course, the house didn't stand, and the destruction was complete. We are not numbered amongst the unwise, and it has taken strong leadership at every level to steer us through the tempest of high crime, serious crime, enough stress, occupational hazards, resource deficits, poor interagency relations, hypocritical opponents, politicking, inadequate remuneration, crises of various dimensions, and the like, and we do it all with a smile. There is an active construction site in the criminal justice arena with varying stages of development as we go across each member state and territory. We hope that there is a master plan that contemplates criminal justice reform that captures these. abolition of preliminary inquiries so that we have committal of cases in a matter of minutes as opposed to a matter of months and years. Introduction of judge-alone trials and jury system reform. Backlog and delay reduction strategies. Introduction and amendment of criminal procedure rules. Modern, future-ready halls of justice and proper accommodations across the board. Digitizing of court and office procedures, and of course, we look forward to regular live stream of court proceedings. A suite of legislative reform. Criminal justice reform committees locally and regionally. Alternative dispute resolution, and we've heard much about criminal mediation. Child or juvenile justice reform. Anti-crime programs. Public education about justice system. And so that this is the state of affairs when it comes to early formal education, so that our young ones could be much more exposed. And of course, access to laws. An enlargement of the defense bar, enlargement. Plea bargaining legislation. Legal aid offices and public defender offices. Probation offices and programs that bring about real change when it comes to rehabilitation of offenders. Witness care, support, and protection. The elevation of witness rights with special measures. And of course, not just witness protection, but justice protection when it comes to the security of criminal justice practitioners in light of violent crimes and escalating gang crimes. Forensic services in the investigation and prosecution of matters. Legal profession legislation. Adequate remuneration and rewards for those in public service. The judiciary, magistracy, prosecution services, police, civil servants who support the justice sector. This list is not exhaustive, imagine that. But the work will be exhausting if there is only a coalition of the willing. There must be commitment and collaboration of all those who are duty-bound. There is need to build the public confidence in the justice system. But as I reflect, as a people, we really do have to choose. We must consider whether we will continue to diminish and rubbish the work and the worth of our key national and regional institutions, such as the court, the DPP's offices, the Attorney General chambers, and the like. Or we can choose as a people to be part of the rebuilding efforts in difficult but exciting times, because this is the age of innovation and justice reform. There must be a resurgence of reconstruction efforts in the justice sector, and it takes a community, not just the court. But alas, as we look to the future, we do so by faith and not just by sight. Today's sitting pays homage to the foundations of the Eastern Caribbean Supreme Court, once headquarters in Grenada, and to the virtue of the rule of law when we consider the history of Grenada. And with the aromatic spices, it captures the uniqueness of the Eastern Caribbean Supreme Court and the people it serves. We honor today, and we will always treasure, the personage and the legacy of Her Ladyship, Dame Janice Pereira, whose wisdom, grace, voice, passion, and efforts are well sealed in the pages of history. We celebrate your excellence, and we do not celebrate your excellence alone, because alongside you are many stalwarts that give yeoman service at the Court of Appeal, at the High Court level, at magistrate courts, court officers, and with all partnering organizations and supporters around the world. We, the prosecuting authorities of the Eastern Caribbean states, we renew our commitment to the court and to the people who we serve. And as I end, the future has supremacy. Yesterday and today must yield to it, and I pray it finds us faithful to the cause of peace, charity, hope, and justice for all. I thank you.
Thank you so much, Madam Director of Public Prosecution McDowell. We now welcome Mr. Thomas W.R. Astafan, King's Counsel, who was born in Middle Island, St. Kitts. He is an honors graduate of the University of the West Indies, Cayville campus. As corrected by Learned King's Counsel, in 1986, he received his legal education certificate from the Ewing Law School. Over the years, he has obtained bar admission in all of the court's 9 member states and territories. In 2014, he was elevated to the rank of King's Counsel. He has also done short acting stints as a High Court judge and Justice of Appeal of the Eastern Caribbean Supreme Court. To address us on behalf of the Inner Bar and as the representative for the territory of Anguilla, Mr. Thomas Astafan, King's Counsel.
Madam Chief Justice, Justices of Appeal, Justices of the High Court, I bring greetings to you from that lovely island of Anguilla, which was the place in which our Chief Justice began her judicial career, and which is why she is as great as she is today, because she started in Anguilla, like Justice Saunders. So Anguilla has done a great deal. Justice Michel too. He started there as well. Now, my lady, we were given a topic for today, but I'll be honest. After all those great speakers before me touched everything, who am I to address the theme? I'm not into the IT, because I don't even know how to set the time on my phone. My son has to do it for me. I'm an old man from an old time, so that's what you're going to hear about today. Now, I don't normally go to church, but 2 things stood out to me when the young priest was given what your ladyship referred to as the homily. So if you would allow me, I must confess at this stage. He mentioned what motivated lawyers to decide to become lawyers. And he suggested that there was some esoteric process. And I felt very embarrassed, personally, because my decision to do law had nothing to do with any intellectual exercise. I had finished studying in Canada, enduring many harsh winters, and my option was to go back to Canada to do postgraduate studies in social anthropology, or I had the option of going to Barbados. Eternal sunshine, cricket, parties. Now, what decision I was going to make? I went Barbados. And as to the cricket part, Madam Justice Price Finley, Justice Michel, Justice Stevenson can attest to that, because they were there with me at the same time. So there was no esoteria involved in my decision to practice law. It was just a weather thing. The second thing, my lady, and this one your ladyship will know what I'm speaking about. I observed a young altar person conducting the ceremony, the young lady with the bells and everything. And I noticed when, at the communion part of it, she went over to the table and was mixing the wine. And it brought back vivid memories of my time as an altar boy in St. Kitts in the late 60s and early 70s. And who was our lead altar boy? A young man called Joseph Pereira. I don't know if he's any relationship with my lady. I don't know that. And when I was looking at the wine, my lady, I was remembering that Joe, and I, of course, and the other altar boys, decided we would become quality control managers for the priests. How would we not ensure that the wine was not stale and that the sediments at the bottom of the bottle when it was finished were not poisoned? So we proceeded to sacrifice day in, day out in ensuring that the wine that the priests would have, if any was left, and most of the times none were left. So those are the two things that impacted me from going to court when I went to church. My lady, one more thing on that topic. And you will forgive me, I'm not going to speak on the theme. Forgive me for that. If your ladyship had eyes in the back of your head when we were in procession from the church to here, you ought to see a bundle of lawyers in the back dancing to the calypso, jamming down the road coming here. Of course, I wasn't doing it, eh? Not me. The AG was. The lady, well, insofar as, let me say this to you, and this is a serious one. I do not think I'm qualified to speak on behalf of the eminent Queen's Counsel in the region, because each of them reach where they are in rank by virtue of their eminence, and I can't speak for them. And if I do say things which is below their level of intellect, they will forgive me. At least Dr. Alexis told me that already, so I'm happy with that. When we were selected to speak, we had a Zoom meeting with our illustrious Chief Registrar. And she told us we had 7 minutes to speak. And I asked if she was serious. I said, you're talking about lawyers speaking, you're telling me they're going to speak for 7 minutes? Well, I was right. Thus far, I have been right. My lady, I'm not, and never have been, a good speechwriter or good speaker. You know that, because you were my judge for 6 years. You know I'm a very shy person. Your ladyship knows that. So you will forgive me for the quality of my utterances today over the next few minutes. Now, my lady, one of the things, in keeping with the directive I got from our dear Chief Registrar, I will reflect on what Shakespeare had to say in Hamlet, Act 2, Scene 2. Polonius says this, "My liege and madam, to expostulate what majesty should be, what duty is, what day is day, night, night, and time, time, were nothing but to waste night, day, and time. Therefore, since brevity is the soul of wit, and tediousness the limbs and outward flourishes, I will be brief." Yes. My lady, everybody, including yourself, have spoken about the great accomplishments of the court from your taking up the office of Chief Justice up until today. And I just wish to echo those sentiments without repeating them. But if we look, what is the future of the court? My illustrious friends who spoke viewed it from the technological perspective, etc. As I said, I'm an old man, can't even operate my phone. So I will look at it as old lawyers do. But Shakespeare again, in order to say what the future is going to be, we need to understand what was behind us. And he says this, in The Tempest, Act 2, Scene 1, in an exchange between Antonio and Sebastian. Antonio, who is the next heir of Naples? Sebastian, Claribel. Antonio, so that is Queen of Tunis, she that dwells 10 leagues beyond man's life. She that from Naples can have no note unless the sun were post. The man i'th moons too slow, till new. Born chins be rough and razorable. She that from whom we all were sea swallowed, though some cast again, and by that destiny, to perform an act whereof what's past is prologue, what to come in yours and my discharge. So that if the past is prolonged, we need to look at the past to know where we're going to be in the future. Now, I will superficially examine it. This court is 57 years old. 1967 West Indies Act, and by virtue of Section 6 of that act, provision was made for the creation of the Court for the Associated States. The Supreme Court order in Council of 1967 made under that Section 6 laid the foundation for the passage of what became the West Indies Associated States Supreme Court Acts in all of the islands. They are now known as the Eastern Caribbean Supreme Court Act, I think except in one island, Grenada, yes. But that's the legislative background to this court. In that 57 years, we have had 13 Chief Justices, and that's important. We had Sir Alan Lewis from 1967 to 1972. He was from St. Lucia. Justice Cecil Lewis from St. Vincent, 1972 to 75. Sir Morris Davis from St. Kitts, 1975 to 80. Sir Neville Peterkin, I think he was from Grenada, 1981 to 83. Justice Neville Berridge, though born in St. Kitts, saw himself as a Vincentian, 1983 to 84. Sir Lascelles Robotham of Jamaica, but a West Indian. He lived in Antigua for time immemorial, 1984 to 91. The Right Honorable Sir Vincent Flozak, Privy Councillor, St. Lucia, one of the greatest lawyers and judicial officers in the world of all time, from St. Lucia, 1991 to 96. Now, again, I have to boast a little bit. The next one, Right Honorable Sir Dennis Byron, Privy Councillor from St. Kitts, 1996 to 2006. Justice Saunders, Adrian Saunders of St. Vincent, 2004 to 2005. Sir Brian Allen of Dominica, 2005 to 2008. Sir Hugh Rollins from St. Kitts and Nevis, 2008 to 2012. And last, and by no means least, our ladyship, my ladyship, 2012 to now, 12 years, from the little island of Virgin Gorda, from a nice little village which I visited, the longest serving Chief Justice in the history of our court. And my lady, I did not intend to address you on you now, so I'll come to it in a minute, but coming back to you. Yes? Now, the passage of time has changed some things, some changes for the better, some not so much, in my humble opinion. I think that the relatively recent times, emphasis being placed on procedural faithfulness with the advent of CPR in 2000 at the expense of dealing with the substantive is not and cannot be good for either justice or for litigants. See Justice of Appeal Barrow and Craig Reeves and Platinum Trading Management Limited, 72 West Indian Reports, 195. And Lord Collins in the Privy Council in Texan Management Limited and others, and Pacific Electric Wire and Cable Company, 4 Law Reports of the Commonwealth, page 1. I would have thought, and I'm speaking for myself, and no offense is meant to anybody in this room or outside. I'm speaking my mind. I would have thought that the whole purpose of justice in a democratic society is to serve the people. It's not to serve institutions. It's a people's court. It's the people's justice. That's what I think. I might be wrong. I may be wrong. Therefore, to deprive litigants of their day in court, civil or criminal, on a procedural point, is to deny them their justice. However, and happily, the overriding objective of CPR, coupled with Part 26.9, provides the judges with the necessary ammunition to ensure that substantive justice is faithfully served. The point I'm trying to address to myself, but loudly, is that litigants must not be stopped in their tracks by breaches of the procedural rules. There is a way you can fashion a remedy to allow them to have their day in court, and we must encourage that, because it's their justice. Insofar as Part 26.9 of CPR 2023 applies, it should be used by the courts in every instance to benefit the citizen's right to justice. Insofar as other rules do not permit the application of 26.9, as some don't, they should be amended to permit 26.9 to prevail. That's just my view. I must also mention the recent trend voiced by many and acted upon thus far by a few, that we should transition to judge-alone criminal trials in our jurisdiction. My lady, no disrespect again to anybody in here. Let me look. I do not think there is another person studied in the law in this room, and no disrespect, who has the experience that I have had in the criminal courts of the OECS. Long and deep experience, prosecuting, defending. And I can tell you, actually I plead to your leadership, there's nothing more just in our system than the word of the jurors. I'll go on. Where does it come from? 1215, the Magna Carta. It was issued in 1215 and altered in 1216, 1217, and 1225. Clause 39 of the Magna Carta states, I quote, "No free man shall be imprisoned or diseased, that is, dispossessed of his property, except by the lawful judgment of his peers in relation to the imprisonment, and or by the law of the lands in relation to the civil aspect, the dispossession." So it is in 1215, in the agreement between the king and the uprisers, in order to settle that, that the first manifestation of the right to a jury trial was born. I wasn't around in 1215, although I'm old, but not that old. Clause 40 of the Magna Carta states this, and this is one of the exemplary points of our court from its inception to now, that this doesn't apply, but I'm going to say it. To no one will we sell, to no one will we deny or delay the right to justice. Of course, we in the context means the Queen, the imperial authority. I mention this clause because there are a series of judgments coming out of the courts of the Commonwealth in respect of the delay right of justice, with the notable exception of the Canadian Supreme Court, which seem to suggest that delay right of justice, as used in the Magna Carta, or the constitutional right to a trial within a reasonable time in our constitutions in the OECS, is a conditional right. That is to say, the right to be tried within a reasonable time is conditional upon something else, dependent upon whether the other rights secured by the relevant section of a fair trial is still possible, regardless of the number of years which have gone by. For completeness, the third right engaged in that section is the right to a fair trial within a reasonable time before an impartial tribunal. Those are the three separate rights encompassed in that section. What has developed, if we read the cases, Turks and Caicos, Bahamas, England particularly, is that the right to be tried within a reasonable time is subsumed under the right to a fair trial. And even if 20 years have passed, the judges will say, well, if he could get a fair trial now, even though we acknowledge that the right to a trial within a reasonable time has been infringed, then the trial can go on. And there's a case from the Court of Appeal out of St. Lucia. Justice Baptiste wrote the decision, which addresses it from my perspective. Time has gone, too much time has gone, it's okay. Now, the constitutional right to be tried within a reasonable time is rooted in the Magna Carta, as I just said. And when the extra-regional judges pass judgment on matters of this nature which bind us, they seem to forget their own legal history, which is why I'm a proud West Indian nationalist. I grew up in the era of strong trade unions and revolution towards independence, etc. That's my background politically. So I have nothing but respect for our institutions. And even if I think sometimes we do wrong things, I still have faith in us. We have to go forward. Now, in closing on that point, I must remind us all that the constitutional right to be tried within a reasonable time is rooted in the Magna Carta. It's not some 1962 onwards fashionable thing. Now, the right to a trial by jury, which is also in the Magna Carta as its root, is a right which evolved from the Magna Carta and was elevated over centuries as a right of common law, and which, when our former colonies got written constitutions, it is my submission that that common law right was elevated to a constitutional right. And in that regard, I wish to refer the court with respect to Thornhill and the AG, 1976, 31 West Indian Reports, page 498 at 512, paragraphs A to C per Lord Diplock. And Maraj and the Attorney General of Tobago, number 2, 1978, 30 West Indian Reports, page 318, paragraphs F to J per Lord Diplock. For the point that common law rights get elevated into a written constitution even if they're not expressly stated in the Constitution. So I say that to say this. Notwithstanding music, and I'm coming to the end now, and you all will see why what I said is important to me. Notwithstanding music, where the Privy Council ruled that the act creating trial by judges only created for the simple reason that they needed music to be tried without a jury, did not infringe the Constitution up there. But then you pause and you say, okay, the Privy Council says so. They are an ancient institution. They are our supreme apex court, so it must be right. But I said earlier, I'm a rebel. I don't think they're right. I think they were political with that decision. And if I mash toes now, milady, you know me very well. I really don't care. Why am I saying it's political? Because it's not the one and only decision which has a political overtone. The Chagos Island cases, where the people of the Chagos Islands, the natives, were removed from their islands so that Britain could contract a lease with the US government for a naval base. That is a political decision. Which brings me to the most important thing I wish to say today, other than what I wish to say about you afterwards. The time has come now when all of us in the West Indies need to accede to the Caribbean Court of Justice and move away from the Privy Council. Let our own people, people who are of us and we of them, who are born with us and grow up with us and experience with us our social and cultural and economic experiences, let them sit in judgment of me and of us, our own people. It is time for us all, and I hope some politicians listening, to begin to focus on transitioning from the Privy Council to the Caribbean Court of Justice. One of the things you hear, well, it's going to be political. Okay, so what? We're human beings. Sometimes we are political, inadvertently. But yeah, the Privy Council is political, which is why I raised those two cases. Two political decisions. Let my own people be political with me, not foreigners. And I mean no disrespect, my lady, you know that. You know me well. Now, milady, I cannot stop without paying tribute to my learned friends, the lawyers. I can't, because I have been through the water park, as it were, in my career. So I have to give them their kudos. Once again, I go to Shakespeare. Henry VI, Part 2, Act 4, Scene 2. There's a conversation between Jack Cade, a traitorous man who envisions a quasi-communistic social revolution with himself installed as autocrat, and Dick the Butcher. They were talking and there were people around, so all the people, God save your majesty, Cade, I thank you, good people. There shall be no money, all shall eat and drink on my score, and I will apparel them all in one livery, that they may agree like brothers and worship me, their land. Dick in response, the first thing we do, let's kill all the lawyers. Cade, nay, that I mean to do. Now I say that on a jovial note. I don't want nobody to kill all of you here. I was just joking. But, in other words, my lady, we need to honor our lawyers, even in jest. My lady, finally, I must speak to you. I speak to you as one of the first lawyers who appeared in court before you when you sat in Anguilla on your first assignment for the first time. I've said it before, and I will say it again. When your ladyship walked into the courtroom, from stage left to center stage, you stunned us all. First with your elegance and with your beautiful outfit. Ladyship dresses immaculately. So that was the first impression. But what was more important was your demeanor. How you dealt with lawyers and litigants. How you were always a peacemaker. How you always helped lawyers, litigants. You were always willing to teach, guide, and assist. And the 6 years you spent there, the hundreds of times I appeared before you. Whatever little bit of knowledge of the law, whatever little good I have in me as a lawyer, came from that experience. And I have to thank you personally for that. You uplifted me, however small the distance of upliftment, but you uplifted me. And I have to thank you for that. Because you didn't have to be the way you were, but it's your natural demeanor. And I know that because I met some of your siblings in Tortola, and they're just like you. Very sweet, very nice people. Lady, in your 6 years as a High Court judge in Anguilla, on one occasion only, you had reason to raise your voice at me above the normal whisper level. I don't know if you remember it. It was a case, a criminal case with Stanley Reed prosecuted. And I threw him a little googly on the side there. You shut us down quickly. But that goes to show your qualities as a person. Because I am of the view that any judge in any court manifests their characteristics and personality in court. And at the risk of maybe offending some people, I don't think we had before you or since you. No offense meant Justice Moyes and Justice Innocent. Another person that encompassed everything to assist us as we had with you. And then you're 12 years on the Court of Appeal, same thing happened. I saw it happen in the courts of appeal, and I am not going to repeat all of the kudos that they gave you about all of the technical innovations and so on. I'm just going to say this before I sit. Madam Chief Justice, one of the most significant things that happened to me in my entire life, particularly in my professional life, is getting to meet you and getting to know you and serving you when asked to serve. I thank you.
Thank you. Thank you so much, Mr. Astafan, King's Counsel, for your warm words. For over 3 decades, the OECS Bar Association has been championing the cause of the wider legal profession and the overall pursuit of an efficient justice system in our sub-region. Today, to address us on behalf of the bar is Ms. Jean Dyer. Just a moment. But regrettably, Ms. Dyer is unable to be with us today, and so on her behalf, representing the OECS Bar Association, her address will be delivered by Ms. Karen Samuel, member of the Otter Bar in Grenada.
Thank you. My Lady Justice Gilbert, with your leave, I would like to adopt the protocol which has already been so ably established, but permit me to recognize Her Ladyship, the Honorable Dame Janice M. Pereira, Chief Justice of the Eastern Caribbean Supreme Court, and of course of the Grenada and the West Indies Associated States Supreme Court. Their Excellencies, Heads of State of each of the OECS member states and territories, Honorable Heads of Governments of each of the OECS member states and territories, and Judges and Masters of the Eastern Caribbean Supreme Court. Distinguished guests, colleagues, citizens and residents of the Eastern Caribbean, on behalf of the OECS Bar Association, I extend a warm welcome to all of you to the opening of the new law year 2024. Unfortunately, due to certain family commitments, I am unable to be physically present in Grenada for this August gathering. Nonetheless, I am thankful for this opportunity to address you on this important occasion for the legal profession. Many thanks to my long-standing colleague and friend, Ms. Karen Samuel, for having graciously agreed to deliver these remarks on my behalf. Today marks the sunset of the preceding 365 days, over which tradition dictates that we ought to reflect on the progress we've made in the last year and on what will, or at least might, happen next. We are at the end of another year of profound change and challenges, both for the world and our profession, alongside a number of proud achievements. As a new legal year starts, my mind turns to the enduring success of our legal system, with judicial independence and the rule of law at its heart. Our justice system continues to grow and prosper, but we shouldn't take that healthy state for granted. We must be mindful of the changes and challenges that lie ahead. We must also reflect on how we individually and collectively, as a profession, might best navigate the future by reshaping the justice system and the practice of law. At one level, the court's function is adjudicative. Our judges, masters, and magistrates determine facts and interpret and apply the law fairly. But there is a second key function, which might be termed as the court's systemic task of developing and operating a system of administering justice that is accessible to all. Both must be fulfilled to secure public trust in our justice system and safeguard the rule of law. There was perhaps a time when trust was secured principally and perhaps even exclusively through sound adjudication. The sound discharge of the adjudicative function alone will not suffice if citizens feel the courts are beyond their reach. Access to justice is the cornerstone of a fair and just society. Our Honorable Chief Justice has already updated you on the notable technological and other improvements which were made to our justice system over the last year with a view to enhancing access to justice. These efforts are commendable, given the budgetary constraints of which we are all aware. Our court, as ever, can only do as much as resources allow. I ask only that our governments provide our court with sufficient funding to continue to deliver core services as well as improvements to our justice system. Access to justice should not be determined by your ability to pay for legal representation. Whilst legal aid is said to be the hallmark of a fair and open justice system, legal aid is in crisis in the OECS and needs urgent reform to protect access to justice for the most vulnerable people within our societies. The OECS Bar Association has, at the invitation of the Honorable Chief Justice, commissioned a working group which has been tasked with exploring possible reforms and alternatives to government-funded legal aid. The legal profession, however, cannot be expected to keep the wheels of justice turning over for the most vulnerable and disadvantaged. The demand for help is increasing. There are many other challenges and opportunities that the OECS Bar Association is working on, several of which are not only challenges for the legal sector. The legal landscape has changed dramatically in the past few years. Whilst the constraints of time forbid consideration of all the changes, two significant trends stand out. First, the COVID-19 pandemic changed lawyers' working patterns. While skilled in handling high-pressure situations, lawyers are now being pushed like never before. Over the last few years, the OECS Bar has worked to destigmatize mental illness, recommend best practices and remedies, and help bring more balance into our members' daily professional lives. It is for this reason that we introduced our annual wellness retreat at our regional law conference, which was held in person for the first time since the onset of COVID-19. Our members were able to disconnect from their clients' concerns and focus on their health and wellness. We had over 150 judges and lawyers in attendance at our regional law conference, and I was pleased to learn it was considered a success. It is intended that the wellness retreat will be an established feature in our annual calendar going forward. The second trend is that artificial intelligence promises to be a game changer in the legal services sector, and as such, simply cannot be ignored. We need to be engaged and conscientious to ensure that AI is a booster and not a buster for our profession. We must, however, ensure that generative AI is used responsibly and ethically. We must also be mindful of the need to protect data privacy, security, and confidentiality while using generative AI. The OECS Bar Association intends to do its part to tackle what is likely to be the greatest moral challenge of our time. We are determined to lead the profession in this important area, not just identifying risk, but also opportunity. Looking to what will happen next, the time has come for us to introduce mandatory continuing legal education as a post-qualification requirement for lawyers practicing in the OECS. With the rapid changes of the world, the rules and new topics, lawyers have to stay up to date. Most other professions require it. Unfortunately, having to complete continuing legal education is seemingly bothersome to some lawyers who feel that they are an unnecessary waste of time. While the value of CLEs may be a source of debate for some lawyers, the importance of continuing legal education is not. It is our duty to ensure we are protecting our profession and clients' interests. During the upcoming law year, the OECS Bar Association intends to progress our plans to implement mandatory CLE. Most of our Legal Profession Acts contain provisions which would govern same, but there is no framework for CLE credits. A committee has therefore been formed to explore and make recommendations on the implementation of a regional accreditation process. My lady, these are a few of the activities which the OECS Bar will undertake during this year. Time does not permit me to address the others, save to mention that we will be celebrating the 35th anniversary of the OECS Bar Association this year. We will be holding several activities to mark this milestone. In closing, I once again wish to thank each and every one of you for joining us to celebrate this important day in our calendar. As far as the administration of justice is concerned, I renew my personal pledge and that of the OECS Bar Association to be untiring in our efforts to continue to defend steadfastly the independence of the judiciary and the rule of law in the OECS. I also wish to place on record the OECS Bar Association's gratitude to Chief Justice Pereira, who has indicated her intention to retire later this year after more than 20 years on the bench. I dare say, without fear of contradiction, that Chief Justice Pereira brought to the court not only her abundant intellect, wisdom, and fairness, but also her enormous capacity to listen, not only to what is said, but also to what has remained unsaid. Dame Janice has inhabited the role of Chief Justice in such a way as to be a role model for many generations who may seek to emulate their preeminence in the legal world. Dame Janice, we in the OECS are so grateful to you for what you have done during the last 11 years, particularly for helping us to navigate the uncharted waters of COVID-19, and indeed, throughout your long and distinguished judicial career. Quote, you have done justice, loved kindness, and walked humbly with your God. My lady, it only remains for me to extend to all members of the judiciary and to the members of the legal profession, the OECS Bar Association's warm wishes and prayers for good health, continuing wisdom, strength, and fortitude for the year ahead. May it so please the court.
Thank you, Ms. Samuel, for that presentation on behalf of Ms. Jean Dyer, President of the Bar Association, the OECS Bar Association. Our next speaker hails from the Helling of the West. She graduated from the University of the West Indies, Faculty of Law, with first-class honors in 2001, and from the Hewarding Law School in 2003. She has served on several boards and commissions in her country, acted as Master of the Eastern Caribbean Supreme Court, and as a registered provider with the Legal Aid Authority. Since 2003, Mrs. Thomas Hunt has actively participated in the St. Lucia Bar Association and is currently serving as its president. to address us on behalf of the constituent bar associations of the OECS and as a representative of St. Lucia, Mrs. Diana Thomas Hunt.
If it pleases the court, my lady, may I adopt the protocol that has been so ably established. It is with deep humility that I stand to represent the legal fraternity in St. Lucia and to address the court and the people of the jurisdictions of the Eastern Caribbean Supreme Court on behalf of the presidents of the bar associations. Bar associations, if I may remind the court and the people of the islands, have 5 main purposes, including to maintain and improve the standards of conduct and proficiency of the legal profession, to represent and protect the interests of the legal profession, to maintain, promote, and support the administration of justice and the rule of law. My lady, I am delighted to report that the bar associations of our islands, being held accountable by their members and by the OECS bar, have all taken actions and initiatives aimed at fulfilling those purposes. The Bar Association is first and most importantly pleased to report that the landscape for practicing law in the Eastern Caribbean Supreme Court jurisdictions will soon change because the Legal Professions Act will now require mandatory membership of the Bar Association, mandatory professional indemnity insurance, and mandatory continuing legal education, among other legislative reforms. These will be implemented in phases as the bar councils work with the governments and the judiciary to prepare the framework to establish fundamental systems and facilities in the working out of these reforms. My lady, I am informed that the BVI has already made its submission to the Attorney General, and in St. Lucia, we hope to make our submission by the end of this term. As we speak, Anguilla and St. Kitts are also well on their way. The bar associations, my lady, also engage in public education drives, such as the Antigua and Barbuda Bar Association's seasonal television program called Bar Talk. Antigua and Barbuda, St. Kitts and Nevis, Dominica, and St. Vincent, and St. Lucia, my lady, have also engaged on legislative review exercises, given that our states and territories do not enjoy the resources of law review commissions. And my lady, this is all done without payment. I am also pleased to report, my lady, that we will shortly see some amendments to the disciplinary rules, which will finally see those in the profession who have committed serious infractions in their practices warranting suspension or disbarment face tougher measures than the Committee for Discipline of Lawyers can impose. My lords, we are holding ourselves accountable, and as part of the reform process, the court has required that we answer to it. During the 2023 period, lawyers were brought under the anti-money laundering registration regime, and in addition to the previously required steps necessary to shield our offices from facilitating laundering of proceeds of crime, we are now required to report to the relevant financial intelligence authorities. This was not without protest, because lawyers were fearful that the independence of lawyers and the privileges that their clients enjoy would be eroded. However, my lady, the reporting requirement does not apply to our functions as advocates. My lady, I'm also pleased to report that the OECS bar and the local bars have commenced training exercises for lawyers in that area. The bar associations have welcomed the reforms to the civil procedure rules implemented during the last year by the court. The new buzz phrase among my colleagues, my lady, is judicial settlement conference, and another is we have to refer to the sentencing guidelines. My lady, we welcome these reforms. We've also welcomed, and I beg to differ a bit with my learned senior colleague, Mr. Astafan, the changes where the court has gone back to removing the requirement where every single procedural step has to be taken in order for relief from sanctions to be granted and in order for default judgment to be set aside. We welcome this development, my lady. My lady, the Bar Associations also welcome the recently passed pre-action protocols, particularly the ones mandating the parties to attempt pre-action settlement of the disputes in a more structured way prior to initiating court proceedings. We know that the judges of the court are attentive and cordial, but we as lawyers need to remind clients that the court is not a friendly place. The public sometimes are not advised that a court is but one place to resolve disputes, and it should rightly be a place of last resorts. My lords, in the dispensation of justice and the maintaining of the rule of law, we are content to walk in that path with the court. My lady, so many have spoken about the court's prowess in innovation and in moving forward with technology. I am informed and advised to communicate to the court that by eliminating the need for paper filing of court documents throughout our courts and the magistracy, the court, it has been said, has now become almost hurricane-proof and COVID-proof. My lady, it was not entirely as a result of necessity. We believe that it was also as a result of foresight. And my lady, in this process, the court has also reduced its carbon footprint, contributing in a very small part, but significant nevertheless, to the global temperature climate goals that we hear about so constantly. I also wish to highlight something that happened to me earlier this week where a young person walked up to me and she said, "I saw you on YouTube." I'm never on YouTube or I'm not on social media. And then she said it was some big event to do with the court and I don't know what it's about, but it happens every year. And then, my lady, a lively discussion between us was generated and I got the opportunity to explain to her what the court is about. We have before, my lady, failed the young people. We do not have in our curriculums anything about the court system. One of my colleagues spoke about it before. And it occurred to me when the registrar strong-armed me into coming to this discourse on this sitting, it was because we are now speaking through the young people media. We are speaking their language. They now know who the chief registrar is and what she does. They now know who the Chief Justice is and what she does. My lady, my lords, this court has actually begun to penetrate the future. And so, in my opinion, the theme is quite fitting. On our side, my lady, we are following the court's example and encouraging our members to subscribe to online resources through the OECS Bar's initiative. And those online resources are already using artificial intelligence research methods. And so we are also encouraging our members to use social media resources. My lady, with the court's permission, I would like to put on record the Bar Association's statement from every single Bar Association president, how so full of gratitude we are that Your Ladyship, Chief Justice Dame Janice Pereira, chose to serve us, the people of these our cherished islands, when, given your several talents as a legal luminary and a formidable administrator, you could have chosen an easier career path. I am asked, my lady, to thank you. Having heard the several speakers who have gone before me and noting the erudite colleagues who come after me, I do not believe that I can be of any further assistance to the court at this time, unless Your Ladyship requires me, and so I am much obliged.
Thank you, Mrs. Thomas Hunt. Mr. Francis Paul hails from the Spice Island, Grenada, and is a graduate of the University of the West Indies, K-Vale campus. He obtained his Bachelor of Laws degree in 1999. In 2001, he received his legal education certificate from the Wooding Law School. He was called to the bar on the 19th of October of 2001. He is a private practitioner and principal of Francis K. Paul and Associates, and is a trained court-connected mediator. Mr. Paul has been an active member of the Grenada Bar Association and is currently serving as its president. To address us on behalf of the host Bar Association of the OECS, Mr. Francis Paul.
May it so please the court. May it so please you, Madam Chief Justice. In the interest of time, may I please be permitted to adopt the protocol so ably established by the speakers before me. My lady, in preparing to deliver remarks today, I sat and wrote a script, wrote my speech. But after listening to the speakers before me and looking at the time and seeing that I'm the 8th speaker and knowing that I have 7 minutes to deliver my remarks, I would just discard my script and I would just, as we say, talk on the fly. My lady, it's indeed a privilege, an honor to have been afforded this opportunity to make remarks on behalf of the Bar Associations. And I dare say that this opening can be considered as historic, be one that is significant because it is the first full in-person hearing since January 2020. Last year we had a blended or hybrid system of opening whereby you have the opening in Anguilla and you have speakers from the different regions appearing virtually. Now COVID ravaged the world so much, and the measures restricted our civil, political, economic, social, cultural, human rights and freedoms that we all had to stay away and could not congregate and could not meet in court as we are doing now. My lady, at a point in time it appeared that the pandemic was actually shredding the fabric of our court system because we have limited hearings. And I must say one of the remarkable initiatives of the court was appearing remotely. Remote hearings, what it did was give us the convenience to appear virtually, give litigants the same convenience to appear virtually while judges sitting wherever you are, based on the notice of 24th April 2020 that wherever, from whatever location a judge or master or registrar conducts a remote hearing, it is deemed to be the court. Lady, I find the theme to be very fitting because we have seen advancement in technology at quite an alarming rate. And the global legal landscape is constantly changing. The law procedures and processes, therefore, must adapt to these changing landscape and contour and grow with it. The court, under your formidable leadership, Madam Chief Justice, have been very proactive in exploring and implementing new initiatives to conform with the changing landscape. And we all know these initiatives, the launch of the e-litigation portal, which make filing and the access to justice quite flexible. You can file at any time. You can file at 2 in the morning at your convenience. You can review documents at any time. Also, the e-litigation portal for the Magistrate Court, which was launched last year. Another initiative by the Eastern Caribbean Supreme Court to include the Magistrate Court under its umbrella to provide that same convenience and flexibility enjoyed by litigants who file in the High Court and Court of Appeal. The sentencing guidelines, which have proven and brought transparency and consistency to sentencing for the subject offenses. The civil procedure rules. And I must say that the rules in its revised edition 2023 has evolved to conform with the changing landscape and time. It has changed some of the processes and procedures to maintain the access and administration of justice. I am sure that I, as well as others, find these rules to be simpler and more practical, and that is evident from the speakers before me who commented on the rules, particularly the ADR feature. I know the criminal members of the bar, we welcome sorry. There the humor come in. The members of the criminal bar. Thank you, my senior. The members of the criminal bar. We welcome the bail rules, the long-awaited and anticipated bail rules. But I must say, while we embrace the innovation and justice reform, and we await other initiatives, we look forward to the criminal mediation initiative. Looking towards the future, these innovation and reforms, it is submitted respectfully, must be optimized when all the resources are available to ensure the implementation works as well-oiled machinery. I submit that the access to justice starts at the doorstep of the registry and the respective court offices. My colleagues here at the bar in Grenada are fully aware that the challenges we are faced with daily at the Supreme Court Registry, one being lack of human resources. There are just not enough personnel to ensure that the innovations are realized. I am therefore urging governments, the executive, particularly here in Grenada, to ensure that the Supreme Court Registry and the court offices are adequately and competently staffed so that the court can function efficiently. Maybe I can be so bold to even suggest that the Eastern Caribbean Supreme Court be given the autonomy to fully manage and determine staffing at the registry and court offices. I also make a clarion call to the executive and government in the region to put the requisite policies in place to have the magistrate court fully integrated into the judiciary. Too often the magistrate courts and magistracy, which are fundamental to the administration of justice in our Eastern Caribbean states, are neglected. And one just have to look daily at the magistrate court list in Grenada and compare it to, for instance, the High Court list. It is most times 3 or 5 times that volume. Access to justice, innovation and reform should therefore be implemented at all levels of the court in our various jurisdictions. Also, as we embrace the technological advancement of the court, particularly creating a paperless trail, we have to be mindful of the lurking presence of cyber threats, or cyber attacks, which can disrupt the computer information system, computer networks, and infrastructure. Ransomware is one such form of cyber attack. And what it does, it blocks your access to operating system until a ransom is paid. So we, as attorneys, colleagues, must sensitize ourselves on cyber attacks, cyber security to protect our data and the data of our clients, since all information, and most of the information of our clients may be in cyberspace on the e-litigation portal. Finally, if the court would allow me to address you, Madam Chief Justice, as one of the longest serving Chief Justices, you have served the court and the Eastern Caribbean states with distinction. Your acute intellect, formidable leadership, and vision has definitely transformed the Eastern Caribbean Supreme Court. We in Grenada are eternally grateful for your service. You have set the Eastern Caribbean Supreme Court on the pathway to becoming a model court comparable to any court in the region or in the developed world. The Bar Association here in Grenada affirms its pledge to maintain the rule of law and to uphold the independence of the judiciary and to embrace the reforms and innovations of the Eastern Caribbean Supreme Court and maintain justice, access to justice for all. Permit me to take the opportunity to extend warm wishes to the judiciary, the court, and colleagues as we continue to embrace the innovation and justice reform of the Eastern Caribbean Supreme Court during this law year, and look forward to the vibrant and viable future of our esteemed Eastern Caribbean Supreme Court. Thank you. May it so please the court.
Thank you, Mr. Paul. Our next speaker is the Managing Director of Watts & Associates Limited. She's admitted to practice in Montserrat, Antigua and Barbuda, and St. Kitts and Nevis. Her previous work experience includes Head of the Government Services and Commercial Banking Units at the Eastern Caribbean Central Bank, St. Kitts, and Economic Statistician, Government of Montserrat. Ms. Watts is a trained court mediator and has served as Secretary of the Montserrat Bar Council, Chair of the Physical Planning Appeals Tribunal, Chair and Director of the Financial Services Commission, and Board Member of the Montserrat Land Development Authority and Montserrat Community College. To address us on behalf of the senior members of the Outer Bar and as a representative for Montserrat, Ms. Marcel Watts.
Madam Chief Justice, I seek your leave to adopt the protocol that was established at the opening of the law year on your feature address. I deem it a privilege to be amongst this august body of legal luminaries, and I extend warm greetings to all attendees and to those persons viewing or listening to simulcast. On behalf of the Montserrat Bar Association, the Honorable Attorney General, Director of Public Prosecution, Chief Magistrate, Registrar, and Deputy Registrar of the High Court, and their staff. When I converted, or when I changed careers, I was asked the question, why become a lawyer? Because per capita, we had a significant number of lawyers. And my very simple answer was, I hope that I could change the way in which persons view lawyers. Mindful that it becomes a challenge to keep one's interest when viewing a simulcast, especially after 3 hours, I will endeavor to be compliant and confine my presentation to the 7-minute directive. Milady, kindly permit me to address you briefly on the theme, Innovative and justice reform with a local twist. 29 years ago, on 19th July 1995, the dormant Soufriere Hills volcano roared to life, disrupting lives and livelihoods and transforming the island's landscape in its wake. Innovation, much like the volcano, with its transformative power and explosive creativity, can disrupt existing paradigms and cause a seismic shift as new ideas and inventions emerge. Streamlining court processes and procedures through technological innovations, such as the implementation of the electronic filing system and virtual courts, while it departed from the status quo, it has served to improve efficiency, reduce delays, and has greatly enhanced access to legal services. Milady, the electronic filings have been welcomed by the attorneys who can file documents at any time and from any location, and it is even more so welcomed by the registry, which has been human resource constrained. The ability to attend hearings virtually, which was necessitated by the emergence of COVID, remains in operation in the High Court, and it was recently implemented in the Magistrates' Court. In Montserrat's case, where many residents are situated in various parts of the world, video conferencing enables their remote participation in hearings. Milady, you have actively encouraged the use of alternative dispute resolution mechanisms, primarily by way of mediation. Regrettably, unlike other jurisdictions, the success rate at mediation hearings has been low, thereby extending the time it takes for a civil matter to get to trial. My lady and my lords, there is a critical need to ensure that the underrepresented groups are not denied access to justice. In Montserrat, we have noted an increasing number of self-represented litigants in the criminal courts. We are acutely aware that all individuals should have equal access to legal remedies, advice, and representation. And in an effort to foster innovation and reform, it is expected that there will be renewed collaborative efforts by the Montserrat Bar Association, local government, through the Attorney General's chambers and civil society organizations, to offer community clinics, pro bono initiatives in its endeavor to what we hope will be the ultimate establishment of a legal aid unit. Innovation in legal education can equip legal professionals with the skills and knowledge to navigate complex issues in justice reform. Investing in continuous education and training sessions is encouraged, as this will redound to our benefit in adapting to the evolving legal landscape. And so I was particularly pleased to hear that mandatory continuing legal education is on the OECS Bar Association's 2024 agenda. Innovation continues to play a pivotal role in justice reform by harnessing, as we've heard earlier, new technologies such as artificial intelligence, data-driven solutions, and collaborative approaches. As Montserrat prepares for the mutual evaluation later this year, in April of this year, these tools have proved especially useful when seeking to gain insights on terrorist financing prosecution and the various legislative amendments and updates. Reform also involves reviewing and updating outdated laws. And some areas in which local legislative reform is required and will be pursued includes amendments to the Evidence Act to facilitate the admission of electronic evidence, the Supreme Court Act to address human rights issues, data protection and cybercrime, and the Labor Code to institute a ceiling on the amount that can be awarded by the tribunal. Although innovation and justice reform exhibits different characteristics, when compared to the activities of the volcano, both are driven by and encapsulate the forces of change, transformation, and impact. In closing, the intersection of innovation and justice reform provides innumerable opportunities to transform our legal systems, making them more transparent, effective, equitable, and accessible for all. Finally, but most importantly, Madam Chief Justice, as you approach the end of your illustrious career at the bar, on the bench, and latterly as Chief Justice of the Eastern Caribbean Supreme Court, where you spearheaded many initiatives and innovations in the legal system, and no doubt leaving a lasting legacy, it is undoubtable that this has paved the way for your successor as we continue with much needed justice reform as we look to the future. On behalf of the Montserrat Bar Association and on my own behalf, I want to wish you a happy retirement, and we look forward to welcoming you again to our island paradise, the Emerald Isle, where we welcome you for some rest and relaxation. May it please you.
Thank you so much, Ms. Watts. And we will now hear from Mr. Peter Ferrer. I hope I have pronounced your name correctly. He is the co-head of the Global Litigation and Insolvency and Restructuring team at Harneys. He's an experienced trial advocate who regularly appears in the British Virgin Islands Commercial Court Division, the ECSC Court of Appeal, and the International Arbitration. To address us on behalf of the members of the Outer Bar and as a representative for the territory of the Virgin Islands, Mr. Peter Ferrer.
May it please the Court. Madam Chief Justice, my lords and ladies, thank you for the invitation to speak on behalf of the Outer Bar of the Virgin Islands. As the previous speakers have, I adopt the protocol already established. I confess it is a rather daunting experience talking to this many members of the judiciary in one go, and my learned fellow practitioners at the bar. And that's particularly so because I don't have a client behind me, because normally I can blame a client for any bad submissions that I'm about to make, and I can use the judicial code I am instructed that, which, as every judge knows, it's not exactly what the barrister himself wishes to say. I have, however, been fortunate enough to confer with the Executive Committee of the BVI Bar Association, so as I'm more used to making legal submissions, I propose to do exactly as I would normally do in court and give you a roadmap. And I have 7 points, if you wish to take a note, my lady. I have 7 minutes in which to make those 7 points. The first point, my lady, is that the Bar Association would like to thank Justices Walbank, Mangatal, Tilak Singh and Young on the hard work and dedication they have shown over the past year. It has, in the BVI, been a very busy and demanding year, and as all practitioners know, without the judges doing their role, we would have nothing. A special thanks also is due to Justice of Appeal Webster, and perhaps more importantly to his long-suffering family, who have agreed that we can have him for at least 6 months, as he is coming back as a commercial court judge in the territory. Point number 2 relates to legal aid. and this continues to be a topic on which the BVI Bar Association is working on. An informal consultation with stakeholders is taking place as to the current scheme, alongside the OECS Bar Association regional review, and that is something which the Bar Association is looking forward to seeing the developments over the coming year. My third point relates to legislative change, and it cannot be underestimated that the introduction of the CPR has been extremely warmly welcomed in the territory, and a great deal of credit ought to be given to Justices of Appeal Webster and Ventrose for their chairmanship of that committee. As you will know, my lady, the BVI is a jurisdiction which is a predominantly international, has a predominantly international focus, and the changes to the service out provisions where you can self-certify, the changes to the alternative service where the standard is reduced from impracticable to good reason will undoubtedly lead to efficiencies both in court list and also in the administration of justice. In terms of the court practice, the return to in-person hearings over the course of the year has been welcomed, together with the flexibility that the judges have shown that on occasions where Zoom hearings are more appropriate. However, the resourcing of the commercial court remains an issue which the territory is very, very much aware of, with litigation at an all-time high, and there is a strong case for 3 full-time judges if we can try and get as many as that. If Virgin Gorda gets ever so boring, obviously you can come across to Tortola, my lady. There is a courtroom that may welcome you. So we hope that the decision in relation to the number of judges we have, particularly in the commercial court, will be on the agenda for this year. My fifth point is to give thanks to the OECS Bar Association for their continued efforts to foster long and lasting relationships across the member states, and we understand that they had a very successful regional conference in Miami in October. My 6 points is a comment in relation to AI, and there is barely a conference that goes by without artificial intelligence being on the agenda. You may be aware, Your Ladyship, that in England, Lord Justice Burse stated that one of his paragraphs that he had written, or rather he had got ChatGPT to write, appeared. He said it was jolly useful, although he was obviously very keen to make sure that it was an area of law that he was very familiar with, and it was only in relation to the law and not in relation to the facts of the case. Unlike the case in the States, where there was either misguided or overworked, whichever adjective you wish to refer to, junior US associate who decided to use ChatGPT to draft a motion, which he then submitted to court. Unfortunately, ChatGPT was so successful that it made up the cases. So it simply had the format of a case with a proposition attached, and he hadn't done his homework in terms of checking to make sure they were in fact genuine cases that he had referred to. I decided to see whether or not ChatGPT could help me write this speech. And so I looked on the website, ChatGPT. You have to log in and you put your email address and you can sign up. It is free to use. And it is scarily good. However, it was so good that when I put my points in, it came to a speech longer than 7 minutes. So I couldn't do it. Apparently, you can use it for engaging conversation, as well as various other things. I did ask it whether it was going to take over lawyers' jobs. And if you put that question in, you get a list of about 7 points. The last of which says that court advocacy is intrinsically human. So in terms of advice to the future generation, I think they have to join the bar, because at least this aspect of our working profession appears to be safe. On a serious note, however, it is inevitable that this court will have to look at those issues in relation to AI and whether or not any guidelines ought to be developed for practitioners. For example, at the moment, the way a witness statement or affidavit is produced is that often a checklist is sent out to the client with specific questions, and the client will fill in those specific answers, and then a junior lawyer will look at it and will create a witness statement. It's sent back to the client. The client will, yes, I say this is my evidence, and he will sign it. He or she will sign it. Now, what happens if, for example, that checklist is put into ChatGPT, and therefore the ChatGPT simply generates the witness statement? Is that something which ought to be disclosed to the court? How is the court going to value that judgment? What sort of treatment should that be given? Similarly with submissions, if it is there is a US website called chat.us, which is specifically for US bankruptcy law, and if you put in a question as to law, within a matter of seconds it will produce a document which, to my untrained US eye, looks extremely competent and genuine. Now, to what extent should submissions be disclosed as having been generated by AI? All of these are issues which the court, in the coming years, will have to address. My final point, and I think I'm within my 7 minutes, is that it would be remiss of me not to thank your ladyship for your dedication to public service and your leadership over what has been a very tumultuous few years dealing with the aftermath of Hurricanes Irma and Maria and the COVID pandemic. It has not gone unnoticed on a global stage that the Court of Appeal barely broke its stride and was able, with the introduction of the ELP and Zoom hearings, to continue as normal, while other dockets around the world suffered backlog. Just by way of example, I had one case where there were parallel proceedings. We started in Hong Kong at the same time as we started in the BVI. The BVI has had the first instance trial remotely, the Court of Appeal remotely. We're now on the way to the Privy Council. They are still waiting for judgment in Hong Kong. So it has not gone unnoticed, I think, in the rest of the world, how efficient the Eastern Caribbean Supreme Court has been. So in conclusion, I wish the court a successful 2024 and that it continues its impressive work of administering justice throughout the member states and territories. And I hope to see you in the Baths or somewhere in Virgin Gorda at a date in the near future. Thank you, Chief Justice.
Thank you, Mr. Ferrer. Our final speaker comes to us from the Nature Isle, the Commonwealth of Dominica. He's a graduate of the University of the West Indies, Cave Hill campus, and the Hugh Wooding Law School. He was admitted to practice in Dominica in 1996 and has served briefly as the Acting Attorney General of Dominica. Mr. Lawrence practices election law, public law, international finance, and banking law extensively. To address us on behalf of the members of the Utter Bar and as a representative of the Commonwealth of Dominica, Mr. Lennox Lawrence. Mr. Lawrence.
May it please you, my lady, Madam Chief Justice, and honorable justices of the Court of Appeal and of the High Court, I am honored, I'm deeply honored to address this special sitting today, my lady, which regrettably is your ladyship's last sitting. And my lady, originally I considered an address which I sent to Siri to read over to me. And when Siri read it to me, I realized I had to edit it down. So the version I will give, my lady, is the version edited down after Siri read it over to me. But it was Samuel Johnson who said, "Don't think of retiring from the world until the world will be sorry that you retire." My lady, it is clearly beyond any doubt that there is acute sorrow and deep regret that your ladyship is at the eve of retirement as Chief Justice. There is undoubtedly clear consensus in Dominica that during your ladyship's tenure, the court had matured and grown in efficiency and capacity and is now well positioned to surmount all current and future challenges that the court will face. But like the speaker before me, I only propose to address 5 issues. He addressed 7. My learned senior, Mr. Asafan, addressed many. I will only address 5. But point number 1, which I wish to address, is the issue of the retirement age of judges. The Supreme Court order of the laws of Dominica provides that a judge of the Court of Appeal shall hold office until the age of 68 years, and a puisne judge until the age of 65. With reference to this theme, innovation and justice reform, the ECSC looking to the future. If we are to look to the future, considering the prominence and the capacity and the distinction of your leadership's tenure, I think it is timely that consideration be given to increasing the retirement age of judges. Because it appears, my lady, that the retirement of your leadership could only diminish the court and would not enhance it. And it is regrettable that someone of the capacity and of your leadership would have to retire simply by the accident of age, as opposed to issues of capacity. My lady, in the words of Ingrid Bergman, getting old is like climbing a mountain. You get out of breath, but the view is much better. My lady, we have benefited from the better view that your leadership has provided, the better perspectives that your leadership has brought to the court. Point number 2, my lady, the issue of judicial settlement conferencing. With respect to innovation and justice reform, the Judicial Settlement Conference introduced by your leadership and championed by justices such as Justice of Appeal Kukuram, Justice, our own beloved Justice Jacqueline Josiah Graham, Justice Fulgence, and Justice Pariat Singh. This must be highly commended as the pilot started in Dominica. And I was fortunate to have been part of the first 2 judicial settlement conferences in Dominica. And it is remarkable how the very combative approach to litigation is quickly dispensed off, and a more conciliatory, resolution-driven approach, my lady, is taken over within the first half an hour of the conference. And we are delighted that the JSC has now become mandatory across the region. And for our colleagues across the region, we wish to commend it for their consideration and to indicate that quite a bit will happen in very quick time. It is result-oriented. And additionally, my lady, the issue of enforcement does not really become a problem because the parties have arrived at a solution as opposed to the court imposing a solution on the parties. So looking ahead, my lady, we think it opportune that the judicial settlement conferencing should be expanded to other areas. And possibly it should also be considered for the magistracy and in areas of family matters, civil matters, and also in private criminal matters, that it might, because there is such a backlog in the magistracy. And with the speed at which resolutions are arrived at in the judicial settlement conferencing, we are of the view that it should be considered as well for the magistracy. And issue number 3, my lady, the issue of real-time court transcription, and your leadership referred to it in your address. In looking to the future, we consider it opportune that reform should be taken at the level of real court transcription. At present, as is well known, the judges are still required to write their notes manually. Even with audio recordings, sometimes the quality is not great. Sometimes the mishap happens and the audio disappears, or there are other accidents that take place. And we consider, my lady, and we would wish to submit with great respect that the time is opportune, that real-time court transcription could save a lot of judicial time and also assist with the speed at which trials will take place. With issue number 4, my lady, if I'm permitted to address it, the issue of internet defamation. It was sometime, my lady, in 2001, 2002, that the first internet defamation case was filed in Dominica. It took us 8 years to get to a judgment, which we obtained in 2009. I think it might have been the first internet defamation case within the jurisdiction of this court. A feature of that case was that we were able to determine the source of the defamation through the email addresses. At present, however, there's a lot that takes place by way of internet defamation where persons keep their identities unknown. They hide behind fake addresses very often. And the question is, how do persons who are victims of internet defamation receive justice? And it appears, my lady, that it may be timely to consider the responsibility and the duty and obligation of internet service providers as a way forward, and to ensure that internet service providers understand their duty and obligation to the public. And if they default and there is a breach of that duty, that they could become liable even if the source of the defamation is not known. In much the same way as radio stations who facilitate defamation could also be liable, lady. So that may be a way, a matter that could be considered by way of innovation. My lady, there is issue number 5. Am I at issue number 5, my lady? Yes, indeed. My lady, the issue number 5, by way of innovation and justice reform, the issue of cannabis. My learned senior paused. But in 1988, the Drug Prevention and Misuse Act of Dominica was legislated. Cannabis and cannabis resin was criminalized as a controlled drug. The act made it an offense to be in possession of that drug. However, Section 9 of that act empowered the minister to make regulations to exempt a controlled drug, including cannabis. That section further empowered the minister to make regulations that may in particular provide that that possession be lawful if done in accordance with a license. The unique feature, however, of Section 9 is that it is restricted substantially to 4 areas: to the public interest, for the purpose of research, to medicine, or to such other controlled drugs permitted under license by the minister. In this regard, it is important to consider the role of the court in that matter. As it appears, my lady, that the court is, and it is well accepted, that the court is the guardian of the public interest. So if the license can be issued under public interest considerations, then there may be matters for the court to litigate. Additionally, if there are issues of the granting or the withholding of licenses, there may be matters of judicial review or other public law areas with respect to the granting or withholding of licenses. Additionally, there might well be conflicts between the areas of unscientific herbal medicine treatments and scientific research in cannabis. So what would happen, for example, if someone is injured through traditional use as opposed to someone being injured with medicine that come out of scientific research? So there are many matters that would come out in the court's consideration or for the court's consideration on the issue of cannabis. There are innovations in St. Kitts, I believe, where they are considering the economic use, and also I think in other areas they have looked at the issue of religion for Rastafarians. Both areas, in my respectful view, are limited in the approach, and the approach should be far wider. But having exhausted the 5 areas I wish to address on, it only remains for me to conclude, Milady, in conclusion, I wish to say that we are here today looking to the future, but celebrating the achievements and the progress that your leadership has spearheaded over the years, over the 12 years. The future will undoubtedly be fashioned by the structures and policies introduced by your leadership. In several respects, today's sitting takes us back to Memphis, Tennessee on April 3, 1968, as we consider the imagery of Martin Luther King Jr. as he contemplated the progress made in the civil rights movement, but well knowing that there was a long journey ahead. May your leadership permit me to the indulgence of quoting the words of Martin Luther King, as it not only captures the watershed moment that we are at, but it also spares us ahead to look at the future. And my leadership, I wish to quote a part of the speech of Martin Luther King Jr. that he gave in Memphis, Tennessee. And he said this: "Well, I don't know what will happen now. We got some difficult days ahead, but it doesn't matter with me now, because I've been to the mountaintop, and I don't mind. Like anyone, I would like to live a long life. Longevity has its place, but I'm not concerned about that now. I just want to do God's will, and He's allowed me to go to the mountaintop, and I've looked over, and I've seen the promised land. I may not get there with you, but I want you to know that we as a people will get to the promised land." My lady, we as a court will get to the promised land because your leadership has taken us to the mountaintop. May it please the Honorable.
This brings us to the end of today's proceedings. As we come to a close, I take this opportunity to thank all of you for taking the time to join us, both in person and virtually, to commemorate the opening of the law year of 2024. I wish to thank all of our speakers who addressed the court this morning or today. Special gratitude is extended to the Grenada Information Services, the Agency for Public Information, UWI-TV, and the Government Information Services of each member state and territory of the OECS. Finally, on behalf of the cohort of judicial officers of the Eastern Caribbean Supreme Court, I would like to extend heartfelt appreciation to Her Ladyship, the Honorable Dame Janice Pereira. Our Chief Justice has served the OECS dutifully for the past 12 years and has truly revolutionized and modernized our court. The effects of her inspiring leadership will continue to be felt after her departure, and for this we say thank you. I just want to digress, and this is an Irish prayer, and I say this to our Chief Justice. May the road rise to meet you. May the wind be always at your back. May the sun shine warm upon your face, the rain fall soft upon your fields. And until we meet again, may God hold you in the palm of his hands. Until we meet again, may God hold you. May God hold you in the palm of his hands. I wish each and every one of you a successful law year 2024.